Would the members of the panel, the witnesses, introduce themselves, please?
Mike Clancy, General Secretary of the Prospect Trade Union.
Andy Prendergast, National Secretary for the Private Sector for the GMB Union.
Thank you. And I'm going to ask Greg Smith to ask the first question.
Thank you, Sir Christopher. Good afternoon, gentlemen. I'll put the same question to you as I put to other representatives of trade unions that we've heard from throughout this bill committee so far. This is quite a wide-reaching bill. Some from other trade unions have even suggested it would re-unionise the economy, to use the words of one on Tuesday. Do you share that assessment? And do you actually feel, and I think this is an important test, whether your unions believe this bill goes far enough?
So I think the primary purpose of this bill is to reset employment relations, of which trade unions are an important part of that. I've got the privilege to sit on the ACAS Council, which is a tripartite body responsible for overseeing good employment relations, good practice. And that actually demonstrates that unions, employers, independents can work together successfully. So that I see as the primary purpose. The reality is that in so many jurisdictions that have positive employment relations are addressing their productivity challenge, unions play a very important role. And so having an objective to have the right level of trade union membership in the economy so that working people have a voice is at the heart probably of this bill. And obviously previous administrations have restricted the ability of working people to have a voice. So yes, I think there is a real opportunity to, one, improve employee relations, two, ensure working people generally have a voice, and three, unions be part of the fabric of the economy in a way that addresses the challenges ahead. So I would say all of those objectives can be delivered by this bill.
You don't think there's any part of the bill that's deficient your union would rather see strengthened, would rather see modified in any way?
I think a key thing that we would like to see is that access to workplaces is not just confined to premises, physical premises, but is also digital. That applies actually where union recognition already exists. We need to ensure that we can address the workplaces of today and tomorrow, not just those of the past. Physical access is important, but many workplaces have remote, hybrid, virtual working arrangements, so we would want to see the bill amended to ensure that digital access in a way that's compliant with data protection is addressed.
What does that look like?
It probably looks like ensuring that the best practice from employers now who do allow us to have access to their intranet, to electronic and digital means in terms of their staff, that becomes the norm and that it complies with data protection. This happens in workplaces up and down the country now, but some employers see the law in a different way. I think a really important thing to get over is that if you are starting to talk to an employer about organising their workplace, the best way to do it is by consensus, to understand the employer, understand the nature of their product, understand what their concerns may be, but also make sure that the aspirations of their workforce, if they want collective voice, are delivered in a way that works successfully for all parties. So this access conversation needs to reflect the nature of the workplace as it now, not just as it has been, and shouldn't be confined to just physical premises.
Mr. Prendergast.
Well, I mean, from our point of view, this is very much a 21st century bill for a 21st century economy, and it's not about looking back, it's about trying to make sure what we have is fit for purpose moving forward. I mean, in terms of unionisation rates, they're around 20% at the moment. I think if you look at a graph of unionisation and then you also look at a graph of rising inequality, falling in productivity, they're almost perfect correlations. So we believe collective bargaining is a way of improving things. I think that's something that's been identified by organisations as diverse as the World Economic Forum and the Church of England. So if this bill ends up with higher levels of unionisation, which leads to lower levels of inequality, we believe that that will be a good thing. In terms of where the bill is lacking, I think like Mike, we need to make sure that there is a digital aspect of access. You know, many of our members working for gig economy platforms in parts of the new economy do not have an old workplace that we traditionally know. It's not a factory, it's not necessarily an office. So we have to talk about how rights can be accessed by people who work remotely, who work from home, or simply do not have a workplace. One other area, I think there is some area that the bill could be strengthened, is we welcome the improvements in SSP, but we don't believe it it goes far enough. We did a survey today which shows that care workers, of those we surveyed in HC1, over 1/3 cannot afford to take sick leave. And we saw in a pandemic, having people go to work when ill, potentially spreading diseases, is bad for everyone. So we think something that could be done on that later on would ultimately help workers and would help the economy generally.
Do you have you mentioned the 20% unionisation rate in there. Do you have a target that you want to see?
Well, I think that the key thing for us is that everyone who ultimately wants to join a trade union has that option to do so, that people are aware of their rights, they're aware that they can join trade unions, they're aware that they have a right to, for example, SSP on day one, statutory holidays, the minimum wage. Rights that people don't know about that can't be enforced are rights that ultimately are no use. So, shamelessly partisan, but I'd like to see union rates being far higher, and I think the economy as a whole would benefit from that.
Thank you.
Minister.
Thank you, Sir Christopher. It's a pleasure to see you in the show this afternoon. Good afternoon, gentlemen. Could I just ask you, generally speaking, do you think the bill will improve working conditions, particularly for those in low-paid and insecure work?
Yeah, I mean, I think this bill is a major step in the right direction. One of the big problems we've seen, certainly over the last 30, 40 years, is this huge increase in insecurity in the workforce. And that tends to have a massive impact both on the individual concerned, their ability to fully partake in the economy, to make long-term commitments in terms of mortgages, loans, the kind of stuff that drives the economy. And ultimately removing what we've seen is as they've lost their guaranteed hours in 0 hours jobs, for example, as they've been removed out of employment rights, those people are less able to exercise those rights. So we see it as a major way of moving industrial relations forward. We'd also point to the work around the pandemic. We, under the last 14 years, were very much locked out from government in most areas, and yet when the pandemic came around, there was a fantastic bit of work between the CBI, the TUC and the government. I remember Rishi Sunak standing on the steps of Number 10 talking about the fantastic work that led to the furlough scheme, that saved millions of jobs, that saved millions of people from poverty. And what surprised us is that great work then was stopped virtually almost as quickly as it happened. Now, if you look at other G7 countries, a tripartite system is what drives higher levels of productivity, lower levels of inequality, and ultimately higher levels of investment and economic outcomes. We think this bill is a long overdue step in the right direction of putting some power back towards workers and away from businesses which too many exist through exploitation.
Obviously, I'd echo those comments. I think if you look at the responses from the business community, yes, there's going to be some anxiety about the detail and how it will work. And I think actually, again, I reference my experience not just in ACAS, but with working with employers more generally. We find ways to do this and operate in practice successfully. Good employers have nothing to fear in the bill. And that's not just good employers who are larger. And we think that with the right degree of consultation moving forward now, which obviously the government's committed to, those areas where there are a few wrinkles and there's things to actually ensure work in practice, we'll be able to do that. I think what you've got to reflect on is what was the alternative. And the deregulatory, more de minimis approach to employment regulation which previously applied, if that trajectory had continued, we are not going to address the issues of precarious work, we're not going to address the issues of productivity, and we're not going to be able to do that in a way which looks at the workforce in the 21st century as opposed to looking backwards. Yes, there's a lot in this bill, but that's not surprising. There's probably a long period of adjustment to address. So I think that with the right consultation going forward now, we'll get to a position where we'll look back at this as a milestone point in changing how we do things, a paradigm shift in relations, and actually will drive better engagement, not just for unionised workforces, but for workforces more generally, because that's where employers will see that they can answer their challenges on the next generation of technology insertion, organisational design, and making sure that they can get the talent that they need.
Thank you. No more questions. Thank you.
Sarah.
Thank you.
Gibson, sorry.
Thank you, Sir Christopher. I was just curious to see whether you felt that the provisions within this bill we're going to encourage and support those who perhaps have been long-term employed or find it very difficult to get back into employment, having lost employment things, and whether the flexibilities that are embedded into the bill are actually going to help people back into work opposed to just helping those that are existing and in work.
Well, as a union who represent a large number of relatively low-paid people, we regularly come across the barriers to getting back into employment. And one of the big ones we've seen on that is the expectation of flexibility, and specifically one-sided flexibility. So, you know, we have a lot of people who are on benefits who want to work. Unfortunately, the only jobs that they're being offered often are 0 hours jobs. And what's difficult, and if you are on benefits, you know, it is a bureaucratic nightmare to get on them. If you coming off them to have a guaranteed wage, to have a guaranteed job, is something that people need to be supported to do. Too often what they're offered is 0 hours contracts, where you're taking the guarantee of certain levels of benefit payments and you're replacing those with uneven levels of reward. What we want to do is get people back into meaningful work. And I think some of the clauses in this bill around, for example, removing exploitative 0 hours contracts, and I thought the point there is exploitative. You know, we look after lots of thousands of Uber drivers, for example. For them, flexibility is very much the driving point. In the same way, there's a number of people on 0 hours, when they're genuine 0 hours, who actually benefit from them. At the same time, we have organisations like McDonald's, like Wetherspoons, who have 80-90% of their staff on 0 hours contracts, and there is no excuse for why that needs to happen. And what we find is that the moment an individual chooses to exercise their flexibility is the moment they stop being offered shifts. And I think that is a major block on people coming back, particularly when you're on universal credit. We want to be able to give people genuine offers of employment to better themselves, to fully partake in the economy and to deliver for them and their families. And I think this bill goes some way to addressing that.
If I can make a general point before addressing more specifically your question focuses upon. I think a failure of our economy for many decades now, which is in contrast to other economies that do have high levels of unionisation, high levels of collective agreement, high levels of partnership, is that we have not taken the fear out of change in the economy. And that can mean that people's reaction to change and their ability to operate in the labour market is correspondingly reduced. A lot of economies are able to ensure that people, if they lose employment, are able to come back into employment much quicker, that there are either statutory minima or collective agreements between employers and trade unions and others to make that happen. And what the bill does is actually ask some fundamental questions about how we want to organise ourselves in the economy, and says that actually having places where we convene and talk about the challenges is better than doing it company by company, enterprise by enterprise, and having a sort of atomised conversation. Obviously, Andy's touched upon 0 hours contracts. We represent a lot of self-employed people, many of whom value the self-employment, and indeed it's part of the process in film and TV production, one thing or another. But they've experienced the precariety of that environment in recent years, particularly in relation to COVID and then subsequently other issues in terms of production. So what this needs to do is holistically look at the economy. I think it's very important to talk about flexibility in a way that it engages all types of worker, not just those who may be able to work hybridly or remotely, but actually all types of worker. And the fact that the bill makes employers, makes unions and others think about the flexibility proposition, that's got to benefit the ability of people to come back into the workplace.
Thank you.
Okay. Annalisa Midgley.
Thank you, Chair. And just before I ask this question, I'd like to refer members to my register of interest, and I'm also a member of the GMB. I just wanted to ask you a bit about balloting and what the practical implications are for your unions with paper balloting, and what you think electronic balloting will bring in terms of any sort of difference.
Well, I think it's been a somewhat a strange situation that, as far as I'm aware, the only legally required paper ballot relates to industrial action. And this creates a major impediment for us sometimes taking industrial action when that is the clear view of the workforce. Now, there was a certain irony not lost on us that when Liz Truss was elected effectively as Prime Minister, she was done so via an electronic ballot. We've been told consistently by people in this House that electronic ballots weren't safe and secure, and yet you can do one to elect a Prime Minister, but you can't do one to take industrial action. What also doesn't help on that, if I'm going to be absolutely honest, is the state of the post office. So we often have to have a fast turnaround on ballots. Where I live, I normally get the post about every 8 days. So what we end up with is an antiquated system which simply doesn't work for this. If you look at electronic ballots, the important thing is that people have the opportunity to take part in a democratic process. It's a process that's allowed under the Freedom of Association rules from the ILO, under the European Human Rights Convention, and I think it's vital that people are able to partake in democracy. So we believe it's actually something of a strange situation that the one area that currently requires paper ballots is industrial action law. If I was cynical, I would argue that that is specifically to stop industrial action taking place. Industrial action for us is always an absolute last resort, but at times it is necessary. And while people don't always like industrial disputes, when you look at what they've achieved over the years, from equal pay via Ford Dagenham to the 8-hour working day to having the weekends off to significantly improved health and safety, it's important workers have that ability to do so and to hold their employers to account. And ultimately, I think something that simply allows them to take part in that democratic process has to be a good thing.
So for too long, the arguments of inhibiting electronic balloting have, in my view, been entirely bogus. And, if you actually look at it from an employer's perspective, they want the most representative turnout if they have a trade union in their midst, and particularly if it's in the context of difficult circumstances where industrial action may be in contemplation. And so does the trade union. We want a representative turnout, and we therefore also want to be able to send a clear message if we've got it to a juncture where bargaining or something else in that process is proven to be difficult. Electronic balloting is exactly going to enable that. And the idea, and this is what I feel the argument's been very bogus, that it can't be done securely, is in the face of all the evidence to the contrary. So I think the sooner that this particular clause is able to be progressed and made real, the better. And clearly as well, it'll not only improve engagement, it'll also improve the validity of these results. And I believe that that's absolutely something that trade unions want. And the sooner we can do it, the better.
Bristol.
Thank you, Chair. We've heard a sort of general consensus breaking out around fire and rehire, and there's a part of one of the clauses in the bill which has a bit of a loophole, to put it bluntly. It's called likely financial difficulties. And we've heard already today and on Tuesday that this could be an open pathway or a backdoor for employers. I'd like to hear your views on that more generally, but specifically you raised today, Andy, about situation with statutory sick pay. It was raised earlier today with Resolution Foundation. Did it go far enough? And the words that were used was it'd only gone halfway. In particular, because statutory sick pay currently stands at £116.75, which is less than 1/5 of the average weekly wage and has halved since it was introduced. It's also the lowest of all OECD countries. And I wanted to ask both of you, in fact, if that's something you want to see changed and improved in this bill, because there's no mention of any increase whatsoever.
We'll both obviously have views, I'm sure, on both the subject. In terms of fire and rehire, so look, this is the space in which some of the most egregious employer behaviours played out, and behaviours which probably most of the business community look away from, because it's not the way they want to conduct the business with their workforces. And therefore we absolutely welcome the fact that the bill focuses upon that dynamic. It has no place in good employment relations. But of course there has to be a space in which you evaluate where if an employer has a genuine financial challenge, that it has some form of defence in that regard. I can't again emphasise enough, because and in a way this is not seen enough in the national media and social media and so on. Day in, day out, trade unions with employers solve problems. They face difficult business circumstances at times, and they work with employers, they communicate with their members, communicate with the workforce, and come out with some form of proposition which goes some way to resolving the issue. The amount of times that employers should fall foul of, therefore, these provisions should be very small. Because if you conduct your engagement with your workforce, either through a trade union or workforce representatives, in compliance with the law, you're not seeking to evade your responsibilities, you see the importance of open book, you see the importance of sharing the finances, because that's all part of keeping the workforce engaged, then this is really a minimum platform to deal with those employers who might sit on the extremes. So I think actually very important it's been addressed. It's sending a message about how we should do business around here.
Can I just press a little bit further on that, Mike? I understand you're looking for, there should be some room for employers who are in extreme financial stress, but the employers who looked at so far, British Airways, P&O, British Gas, Dow Egbert and Tesco's, they're not small companies, they've got deep, deep pockets. They could exploit this loophole that's in the bill. I just wondered what you thought about the language and if it needed to be removed or tightened completely.
Well, look, I think we are going to have to, we will be going through clause by clause, won't we? We will have to look at where there are potential for employers to exploit these sort of loopholes. But I think you've got to understand, often in employment relations, sensible employers read the writing on the wall. So the rights of access may or may not come in for some time, but employers will think, right, we're moving into an environment where we need to engage with our workforce differently. Other employers will say, look, that sort of behaviour is frowned upon in terms of public policy. We're not going to go near it. So I don't think we should lose sight of the direction that the bill sets on these matters. And then if there's detail, and let's be clear, in the context of this is a big endeavour, there'll be detail to work through for both employers and trade unions. And I think we should set out on this, on the way that we need to go forward. Let's do it cooperatively where we can.
Look, just following up on fire and rehire, I was involved in resolving the British Gas dispute, where close to 500 members of ours got fired because they wouldn't sign a new contract. And I think what's, at a time it was roundly condemned across the House. The Prime Minister at the time got up and said it was dishonourable, and that's been very much our view. And I think the real concern for us, as Mike says, we as trade unions sometimes have to make some very difficult decisions. I remember in the following 2008, I would be going into factories, negotiating pay cuts to keep people in work. It was heartbreaking, but we had to do it because it was the right thing to do. And overwhelmingly, we had those conversations not because of fire and rehire, but because ultimately we could convince our members that this was the best way of securing their jobs. And we did something similar over COVID. I think the big issue for us is if you look at British Gas, they're a highly profitable company. They went down a route which frankly was disastrous for them as a business and which they're still recovering from. And we need to stop that behaviour happening. A contract is a contract. I think in this country, it's almost your word, and if you're willing to break that, then it asks questions about whether you honourably went into it in the first place. I think some of the points you make are right. We have seen lots of financial engineering. We see intercompany debt. And I think there is a concern long term that we may find cases where companies have engineered a financial position which allows them to do something they otherwise wouldn't. And I think that will have to be dealt with on a case-by-case basis. Where we have collective rights, we can still take action when we need to around that. But what this does, I think, is a significant step in the right direction of getting to a point where the expectation is contracts are honoured and that simply companies are prevented from boosting profits at the cost of their workforce. Just wider on the SSP point, I think, look, as a trade union, we're used to negotiating improvements, and occasionally we can't let perfect get in the way of good. So I'm pleased that we're talking about an improvement on SSP. Does it go far enough? I don't believe it does, and I think that will have to be looked at long term. I think there's huge areas like care where it's actually catastrophic that people don't feel that they can take that time off. And as I said beforehand, that has a real impact. But at the moment, I'm happy that for once we are talking about an improvement to this. And personally, I'm always of a view we bank it and move forward.
Michael Wheeler.
Chair. As a measure that this is particularly for Mr Prendergast, as a measure that your union has long called for, what do you think the impact of reinstating the school support staff negotiating body will be on your members in schools?
I think when you're looking at the school support staff negotiating body, this was something that has been sort of on the agenda for about the last 25 years. And what we found overwhelmingly in schools is that you have teachers who have national bargaining, very clear terms and conditions, rigorously enforced. Unfortunately for support staff, it is almost like the soft underbelly. And what we find so often is that when schools enter financial difficulties, heads who, when you read the school returns, have often given themselves quite large pay rises, end up cutting hours and pay from some of the lower paid people. Now, what I've seen over the last quarter of a century is a transformation in what schools are like. You know, for most of us, I think when you remember, schools were one teacher and that was it. Now we see increasingly more SEN pupils go into mainstream education. They need that additional support. People from vulnerable backgrounds getting the support of TAs, and we've seen education outcomes really improve off the back of it. So I think for us, particularly as we go into see more and more academisation, more and more fragmentation, we often find as well that there is a sort of undercut and a poach approach from different schools, which ultimately means one is often benefiting at the expense of another. That's not helpful when we get into that situation. So I think what the school support staff negotiating body does is it allows for minimum standards, it allows for the extra professionalisation of roles, which really have changed over the last 25 years. You know, originally there was a little bit of a stereotype. Teaching assistants were there to clean paint pots and to tidy up. Now they do very detailed work on things like phonics, on supporting SEND pupils, on really helping deliver classes. And I think it's time that professionalism is recognised and rewarded.
Nick Timothy.
Thank you, Mr. Chairman. I think you, like all the other witnesses from the trade unions, are quite pleased with the bill, and understandably so. And I know you said that you felt shut out over the 14 years of government until the general election. But I wanted to ask you about your engagement with the department and with ministers, and indeed with Number 10. So how many meetings have your organisations had with official special advisors and ministers, and were you involved in any of the drafting of the clauses of the bill? Did you see any in advance before publication and that kind of thing?
Well, I'll start with that. I mean, personally, I was involved in 2 meetings. They were tripartite ones. They were quite robust exchanges where we had ministers, civil servants, people from the employers industry, employers associations and large employers, and also from trade unions. And I think those meetings were really quite helpful. You know, we were raising points which I think sometimes they would argue and agree with. They raised points that sometimes made us look at things differently. In terms of the wider sense of the union, we have had quite a lot of engagement, but I'd expect a union to be engaged over a bill that has huge amounts of clauses about trade unions. In terms of did we see any of it in advance? No. We were very much holding our breath when the bill came through. You know, part of my job is often to tell people and make cases and be told that they've heard, and then something comes out which is a complete antithesis of everything we talked about. So I think with the bill, you know, as I said, we didn't see it in advance. When it turned up, there were some things we liked an awful lot, some things, as we said beforehand, didn't go far enough. But the majority of engagement was tripartite, and I think both ourselves and the business organisations have taken part in that process, have helped understand it, and we've got to something we can all live with. That's certainly our impression.
Yeah, I just emphasise that Prospect doesn't affiliate to political parties, so any comments I made are based upon evidence of the past and the present. We've had proportionate engagement. We haven't kept a count or a register in that regard. Frankly, probably trade unions and business would want more and more time on this, and I'm sure that will be a challenge going forward. So what I think was most positive, and something I'd not seen in my career before, was a tripartite meeting with a range of very senior business representatives, trade unions and civic society, with officials, with the business secretary and the deputy prime minister back in August. And why that's important is that it demonstrates that actually we can get in a room, we can talk to each other, and we can resolve problems. And that for me is the absolute core of this employment bill and the next steps and the Make Work Pay agenda. And if we can do more of that, something I've talked a lot about, I've had the privilege to do this job for a long time, is that we lost convening spaces in the economy in the past period, where we may be shouting over fences, or we may be making our cases separately to government. The more that actually, government is difficult, and it's about problem solving. The more that business, trade unions and civic society can come together and say, look, we've got our differences at the edges, but we can do this together, and this is how we would fashion an outcome within the public policy you've set, the better. So we'll always want more. But actually, I think, to be fair, with a strong pace and an intensity of it, the government and its supporting officials has done an admirable job in convening us.
Thank you. Thank you very much. I'm afraid we now have to go on to the next panel of witnesses, but thank you for what you've said. Thank you. Okay. I can't hear.
She'd like to make a declaration of interest.
Okay, do you wish to make a declaration of interest now? Okay, let's do it before this new panel comes on. Yes?
It may be that I don't ask a question, but just for clarity, Professor Alan Bogg was indeed my law professor for labour law many years ago, and we were at one point work colleagues, so just for the purposes of reference.
I don't know what the collective noun for professors is, but a proliferation of professors, perhaps. Anyway, could you please introduce yourselves?
I'll start. I'm Professor Alan Bogg. I'm a professor at the University of Bristol and a barrister at Old Square Chambers.
So I'm Simon Deakin. I'm a law professor at Cambridge University.
Melanie Sims, Professor of Work and Employment at the University of Glasgow.
Thank you. Greg Smith.
Thank you, Sir Christopher. Good afternoon to the witnesses. As professors of law, we have heard from other witnesses in this inquiry that this bill in front of us has a lot of holes in it. It is very reliant on secondary legislation further down the track. For such a reforming piece of proposed legislation, do you believe it to be a good proposal not in terms of its content, but in terms of the way you should go about making law? Who wants to start?
Well, I wouldn't say it's got holes in it. It's perfectly normal to legislate this way and to defer complex matters to regulations. As a potential act of Parliament, it's no more or less complex than similar acts we've had in the past. Labour law has always been complex and very granular. But there are many provisions in the Act which will take effect without the need for further delegated legislation. There are quite detailed schedules. I don't have a problem with the way it's been drafted. There are issues about its scope and coverage which we might go on to discuss.
So it's a very ambitious piece of legislation, and it was delivered at lightning speed in 100 days. So I think that's an important part of the context. I think if you take the collective labour law dimension to what's in this bill, it's actually very simple. Much of it is in the form of repeal. There are some proposals for tweaks to the existing structure, but in terms of the collective dimension, I think that the bill doesn't have holes in it. I think that it gives a tolerably clear indication of what the relevant provisions will look like and what needs to be done. I think in terms of the individual provisions, it's fair to say that there is detail that needs to be worked out on day one dismissal protections and on guaranteed hours. But these are very, very complex issues, and I don't think there's anything unusual about that. It's the beginning of a conversation, not the end of the conversation, and that's why we're here today.
So, thank you. I'm not actually a professor of law. I'm a professor of work and employment in general employment relations. So I'm always interested in the system as a whole and how law and then the implementation of all kinds of other pressures on the employment relationship collectively shape employment relationships. I would agree with my two colleagues that it's a very useful starting point. Law can only ever go so far in determining the rules of the employment relationship, and it will always rest on those other wider social systems, economic systems, etc.
From the perspective of making this law, I'm sure you will have seen that the Regulatory Policy Committee has been quite damning of the impact assessments done on this legislation. You said earlier that it's been delivered in lightning speed, so perhaps we shouldn't be surprised that the impact assessments don't necessarily add up. How concerned are you from a point of law, or indeed a point of employment law, that legislation is coming through where the impact assessment has been branded by a very well-respected body, an independent body, as, in their words, not fit for purpose?
Well, the RPC said that about some of the impact assessments, didn't they?
Yep.
They raised a red flag over certain of them. And they're not so much concerned with illegal drafting as with the economic effects of the law. Okay. So the impact assessments are engaging in a cost-benefit analysis, aren't they? Which is attempting to put some numbers on the impact the law might have on the economy in terms of cost to employers and also knock-on employment effects. And actually, they have quite a strict protocol to deal with. What counts as a cost is set out in some detail in protocols which we could discuss. For example, the cost to private parties, to employers, counts as a cost, even if that is simply redistributing to households and to workers. From an economic point of view, what we would be interested in is not so much the private cost, but the impact on the economy as a whole. Do these laws interfere with the way markets work? Are they going to lead to unacceptable costs? Or will they produce countervailing benefits? As a scholar interested in the economics of law, and I researched the impact of labour law, I was surprised by some comments in the RPC documentation. I was very surprised to read the RPC suggest that there may not be inequality of bargaining power in certain sectors like the public sector or transport, where there are very large employers, some of whom are effectively monopolies. There will probably be always some inequality of bargaining power between individual workers and even smaller employers. But we have trade unions and we have collective bargaining because there is that inequality of bargaining power. So the part of the bill that addresses the ability of unions to organise and to organise industrial action in sectors where there are very powerful employers does seem to me to address a fundamental issue of inequality of bargaining power. Elsewhere, the RPC asks for more evidence about asymmetric information and also about productivity. I thought the impact assessments were actually very good in citing secondary sources on those very issues and also balanced. They did cite actually work, I should declare an interest, work I wrote, but they also cited other work. So you'll see in the impact assessments scholars cited who have a less positive view than I do about the economic effects of labour laws. There are no citations at all in the RPC documentation. Now that may be because that's not the job of the RPC, fair enough, but I should have thought that the RPC request for more information and clarification from the DBT is one which could quite straightforwardly be met.
Anyone else have a...
So I won't, I mean, I support much of what Simon said. I think, again, to focus on the collective reforms, because I think there's been some scaremongering about reunionisation of the economy and how radical this all is. And you would think that we were going back to 1965 in terms of the reform of the strike laws, when actually we're probably going back to 2015 with a few tweaks. So the minimum service levels framework is being repealed, but as far as I'm aware, it was never used. There was a prospect of its use once, but it was so inflammatory that the employer in the ASLEF dispute stepped back from using it. And the Trade Union Act 2016 ballot thresholds will be repealed. So I think in that context, and with a few proposed adjustments to strike law, I think this isn't very radical. What it does is it takes the UK from a hyper-restrictive framework in comparative terms to a restrictive framework in comparative terms. And I think in terms of the overall international context, even if all of this makes its way onto the statute book, the UK will still have one of the most restrictive strike laws in Europe.
I couldn't agree more. I think it sets out an agenda which is would be regarded as incredibly restrictive in many other comparator countries, and I think that's better than what we've got at the moment. What we've got is such a restrictive context for particularly trade unions and strike action that actually we have concerns have been raised about the UK's restriction on strike activity by the International Labour Organisation. And this, as it's drafted, doesn't even take us fully, in my judgment, into compliance with some of the concerns that the ILO raises. So, yeah, still incredibly restrictive.
My final question off the back of that, when, let's name him, Mick Lynch told us on Tuesday that this bill is going to lead to the reunionisation of the economy, is he getting overexcited?
I think we have to be realistic about the capacity, the resource capacity of our trade union movement at the moment. I think there are certainly things in here that will make life simpler for trade unions, not necessarily easier, but require less resource to, for example, organise for a ballot or to organise a reballoting during a period of industrial action, for example. At best case, that frees up some capacity to get on with the nitty-gritty of representing workers in the workplace and solving workplace problems. I can't prove that that's going to happen, obviously, but that's certainly a more than possible. So I think, but is it going to free up sufficient capacity to go and try and organise in the breadth of the retail sector, for example, lots of small employers? I personally think that's quite unlikely. I don't think the UK trade union movement has that resource capacity at the moment.
What drives unionisation and strike levels historically is the economy. So high inflation drives strike action, also tends to drive union membership. So union membership, union activity, strike activity is highly sensitive to the wider economic context, which probably doesn't at the moment favour a massive increase in union membership. I'd be very surprised if this particular measure moves the dial much on membership, and I don't think it's going to move the dial much on industrial action either. What could happen, especially with the arrangements for sectoral pay bargaining, is that many workers, whether or not they're in a trade union, would benefit from sector-wide collective norms. That would be the case where the arrangements are going to come in for two sectors which are mentioned in the bill, and hopefully that's just the start. Other European countries, many countries outside Europe, have sectoral collective agreements that in effect set a floor for an industry or sector. I'm not sure whether you'd call that reunionisation, but I think coverage of collective agreements is perhaps more important than simple membership. Although unions depend on membership for their finances, I think the economic effects are going to turn very much upon coverage.
Yeah, as I've said, the reforms to strike law, I think, are fairly modest, and I think that's true of collective bargaining laws. There are two incremental nudges towards sectoral institutions in two sectors, and there are some very modest tweaks proposed to the statutory union recognition procedure, so lowering the preliminary membership threshold potentially and removing the majority support likely threshold. But it's very difficult to see. I don't know what reunionisation means, I must confess, but I'll be very surprised if you see a radical upsurge in union recognition as a result of these very sort of sensible but cautious changes in the legislation.
Minister.
Just to aid the witnesses today, it was actually the Shadow Minister who used the term reunionisation in the evidence session on Tuesday rather than one of the witnesses, which may be why it's not something that's particularly resonating with you. But I just wanted to ask particularly you, Professor Deakin, about the impact of the regulations on increased productivity, innovation, general economic benefits. Do you think this is going to have a positive impact on those issues?
I think so. So the evidence is internationally. There's a strong correlation between stronger labour protection and both productivity and innovation. I think that sentiment in the research community has shifted very much in the last 20 years. That's partly because we have better data and probably better methods. Certainly a generation ago, the World Bank was quite hostile to the idea of labour law and said that labour laws aiming to help workers might harm them. But that's no longer the World Bank's position, and the World Bank has said that there can be too little labour law in an economy, too little protection for innovation and productivity. Of course, productivity has many causes, and the way we regulate labour is only one issue. If we're talking about labour law, though, these reforms are essential to help improve the productivity position. Will this law on its own lead to an improvement in UK productivity? Not necessarily, because that depends upon how we regulate other areas of the economy, and it's affected very much by the way corporate governance works, and also by training and other aspects which aren't all covered by this bill. But is this bill essential in the area of labour law for improving economic performance? Absolutely. And does it go in the right direction? Yes, it does. The research we have done in Cambridge, which I mentioned in the written document I submitted, shows that on average, strengthening employment laws in this country in the last 50 years, on average, has pro-employment effects. That's for various reasons. But that's, as I said in my note, not a prediction or a forecast. But historically, in this country, stronger labour laws are not associated with unemployment.
Could I chip in as well and emphasise the point that Simon's just made about skills and training? I think skills and training both of managers, the professionalisation of managers, and also of our workforce are really crucial ways in which of shaping productivity and innovation. And they intersect very strongly with some of the issues in this bill. In general, the push to professionalise management of work, the managerial decisions, is a really important part of that story, that more complex story that Simon's just spoken to. And the signals through law, but also through other areas of policy, to managers, to organisations, to employers about the professionalisation of their management is a really important thing that the state can do to support that general uptick in productivity and innovation in general.
Professor Bogg, anything you want to?
Oh, I'm just a simple lawyer. I wouldn't like to offer any views on the economics of it all. I'll defer to my expert colleagues. Thank you.
Yes. Well, I'm a simple lawyer too. So, could I ask you then, Professor Bogg, how do you feel the Fair Work Agency will help improve the employment landscape?
So I think this is really the most critical point of all, because we can enact shiny rights and we can put them on the statute book, and if they're not enforced, then there's not much point to this entire exercise. So I think what's going to be critical in this is proper resourcing for a new body. I think the right direction of travel is for that to occur through a new agency, rather than having to coordinate across different agencies. I think that will make things more efficient. I think it's also important that the employment tribunal system is properly resourced. I saw the welcome announcement that the time limits will move from 3 months to 6 months, in line with the earlier Law Commission recommendation. As the Lady Chief Justice said, the rule of law costs money in order for it to be done properly, so the tribunal system will have to be properly resourced. And I think there needs to be a commitment to a principle of effective access to dissuasive remedies. That's absolutely central to all of this working or not working.
Okay, thank you.
Can I pick up on the enforcement case? I think it's important for the committee to really properly understand that those organisations that would be being merged into a new agency have had to cut back to some extent on their advice and guidance to both employers and employees because of the challenges of resourcing over the last years. So they still work in those spaces, but they can't do it at the kind of scale that they have previously, ACAS in particular. And re-resourcing that expertise to support both employers and workers' unions to make good decisions that never become a breach of any rights is really important.
Okay, thank you. Professor Deakin, anything to add?
Yes, thank you. Enforcement's really critical. We don't have an effective enforcement regime in this country. Recent research on the minimum wage, for example, shows that on the whole, employers who don't comply with the minimum wage can actually save money by not doing so and are rarely punished or fined or have to pay wages back in a way that even covers the gains they make by not paying the minimum wage. We're not effectively prosecuting minimum wage breaches. We treat a breach of the criminal law involving theft in a supermarket or another context extremely seriously. We don't treat wage theft seriously to anything like the same extent. There are hardly any company directed disqualifications in the cases of non-payment of the minimum wage, and the message is being given, or has been given, that compliance with these legal obligations is in some sense optional, and not complying can be profitable for firms. We're not the only country in that position. It's an issue also in the United States. But we can do more. We can certainly resource the inspectorate, but in my note I suggested that we can also facilitate collective remedies in addition to individual employment tribunal claims. It's very difficult for an individual to take a claim to a tribunal, and can also be very costly for employers who will have to organise, in many cases, a legal team to fight a case, and they won't get their costs back. It seems to me neither side is necessarily happy with the way the employment tribunal system is working. But collective remedies, in particular through arbitration, which trade unions can bring, hopefully in future to the CAC, Central Arbitration Committee, would be a more effective remedy, I believe, than individual claims are in many cases. So it's not just a question of resourcing the new Fair Work Agency. I think there should be a greater role for collective arbitration, and I made some suggestions in my note based on precedents from the 1970s, which could easily be used again.
Thank you.
Sarah Gibson.
Thank you very much. Interestingly, earlier on today, the Resolution Foundation mentioned that small businesses with no HR departments will struggle without clearer legislation and guidance following this bill. And I have to say that the retail businesses in my constituency, which are all closed because of flooding this week, when we had lots of time between scrubbing floors to discuss the Employment Rights Bill, they made jokes about the fact that they weren't going to be able to understand it. They saw themselves in lengthy tribunals where the tribunals are not sitting. And of course, a lot of their employees are not unionised. I mean, there's a huge percentage of the population, especially in rural areas, where there's no union representation. So both sides are in a very difficult situation here. Are there elements of the bill that you think are lacking in clarity and therefore will lead these small businesses into trouble and therefore their employees into difficulty? Or is that something that should be picked up elsewhere?
Well, there's a difference between a very complex measure written initially for lawyers to implement and communication about that measure once it's enacted. And I believe that the essential changes being made in the bill can be effectively communicated, but I entirely understand the problem faced by many smaller firms who will lack resources very often when they're confronted with a legal claim. They may be able to take out insurance to cover their costs, but often it's the time spent in dealing with the dispute which is the real issue. I researched this about a decade ago, but I don't think the issues have changed. Often litigants, claimants feel unhappy about the way the employment tribunal system is working. Employers also feel often unhappy even if they win a claim. And since that time, there has been an enormous growth in delays before employment tribunal claims are heard. So I think it's a very important issue. Communication from the department to all employers will be essential. But I also think that there is greater scope, there is scope for collective remedies, and I think there's scope actually to reassure smaller enterprises that other firms are complying with the law. So they don't feel that they're coming under pressure not to comply because they see other employers not complying. So I would very much hope that we're moving towards a system of labour law where we would need less enforcement, actually less litigation, and an inspectorate that's trusted by both sides. Countries like Japan or Sweden, for example, have extremely low litigation rates. And that's partly because they have a highly effective inspectorate system, but also because employers of all sides have come to accept the importance of labour standards.
And I think that returns to my previous point about the importance of agencies like ACAS being able to advise in a way that's very accessible. ACAS currently runs a free access telephone service to support anybody with a problem at work, whether that's a small business owner, a manager, an individual employee, or whatever. So that kind of service where people can go to ask questions, I think is incredibly important with any change, to be honest. We know that a lot of the enterprise agencies also offer similar kind of support. So it's those support mechanisms as well as the communication that I think is really important. Just because the law is complex doesn't mean that we have to explain it in a complicated way.
I think these are real concerns, and I think they obviously need to be taken seriously. On the day one dismissal protection, I can see that may well cause real anxiety for small firms. I think the point has been made that you wouldn't expect a small business owner to look through the Employment Rights Bill. I was up at 5 o'clock this morning feverishly sweating as I read my way through it, and it wouldn't be reasonable to expect people without legal qualifications to do that. I think what will be crucial in later phases of this rollout is to have guidance like codes of practice that are written in accessible ways for employers to be able to do the right thing, which actually most employers want to do. So I think that's really important. I think that the area that's going to require a little bit more thought are the guaranteed hours provisions, which I think are complex. I think some of that complexity is inevitable because this is a fiendishly difficult issue given the range of different contractual arrangements that you have in labour markets. But I don't think that's beyond the bounds of smart legislators dealing with this as it goes through the process. Yeah.
Alison Hume.
Thank you, Sir Christopher. Obviously, I can't resist the temptation of having 3 professors in a row in front of us. So could I ask you if you could make one change to the bill, what would it be?
Who wants to start? We were warned about this potential question. I'm going to be very cheeky and I'm going to ask for 2. In the first area, I think making a clear and proactive right to strike and to join a trade union would go a long way to bringing us into line with many of our comparator countries. I also have some concerns about the negotiating bodies looking really quite like pay review bodies at the moment rather than free collective bargaining between the parties deciding their own issues and deciding what works for them. So those are the 2 areas I would focus on.
I would make a change on fire and rehire. I think the provisions on unfair dismissal are helpful, but won't address the problem of collective agreements being undercut. At best, at the moment, the remedy for an unfair dismissal is almost certainly going to be compensation, when what's needed is a mechanism to embed terms and conditions going forward. The Department is consulting on reforms to the interim relief procedure, but I'd go further. I think there has to be a change to the remedy for unfair dismissal so that the previous terms can very clearly be reinstated. At the moment, it's not possible to enforce a reinstatement order. You have to go to the county court even for compensation, but in the case of a reinstatement order, the employer can resist it and just pay compensation. There should, in my opinion, be a collective arbitration mechanism. The Central Arbitration Committee should have the power to reinsert terms and conditions for the affected categories of workers, and that would be true of the persons hired if that happens to replace those who've been dismissed. That mechanism existed under 1970s legislation and would provide the kind of collective remedy that we've just been discussing would be important for stabilising terms and conditions in labour markets and avoiding the need for individuals to bring complex claims before employment tribunals. I also have ideas about zero-hours contracts, but you said just one.
So I've already said I think enforcement is the critical dimension of the conversation about all of this bill, but one specific change which I think would be valuable is to remove the presumption that collective agreements are not legally enforceable. That puts the UK in an almost unique position in the world. I think if you look at the P&O Ferries scandal, one aspect of that isn't often discussed is that there were collective agreements in place, but because of the statutory presumption that they were not legally binding, P&O Ferries were able to put the collective agreements in the bin. So I think, I'm not saying I would mandate them to be legally enforceable, but I would remove the statutory presumption, which would give a signal to the parties that if that they could make them legally enforceable. I think that would bring some real value to the enforcement dimension of UK labour law.
Nick Timothy.
Thank you, Mr. Chairman. I thought I'd just quickly clear up the disagreement that seems to have broken out between the two sides of the committee, and I've gone through the record of Tuesday's session. Paul Nowak said it's very likely we will see increased unionisation as a result of the bill, and Mick Lynch said that the bill will mean that, quote, many workers, hopefully more than 50%, are covered by collective arrangements in one form or another. That's up from 22% today. So I think it's fair to describe that as reunionisation. I don't really understand why I don't really understand why the Labour Party would be so ashamed of doing such a favour for the Labour movement of which it's a part. But anyway, you just mentioned P&O. I just wanted to ask you, who did you think was right about P&O? Was it the Transport Secretary or the Prime Minister when he slapped her down for criticising them?
Not sure. I quite understand the question.
It's about employment rights. We've been discussing P&O throughout the whole...
The question is perfectly... if nobody wants to answer the question because you don't know the answer, then that's fine.
I can move on to another.
I can tell you what I think about P&O.
Okay, look, you don't want to...
Okay,
you don't want to answer.
Nick Timothy.
Can I ask another one? Yes. Okay, so one of my concerns about labour market regulation relates to the use of substitution clauses by firms like Amazon, and Deliveroo and others, where they give a licence to a courier. The courier is then entitled to share that licence with others, and the expectation is that checks for things like the status of the substitute in terms of whether they can work legally and so on, but also the pay that will be provided to that person. That responsibility all lies not with Deliveroo or Amazon, but with the person that they've contracted with in the first place. This isn't dealt with in the bill at all. I think it should be. Can you expand on that, please?
Yes. Of course, the issue of employment status has been deferred, hasn't it, to a consultation. But unless a way is found to include workers like the Deliveroo workers within the scope of protective labour law, then the proposals to improve collective bargaining rights and many other rights will just fall away. That's right. Large businesses like Deliveroo, I would say, need workers, and if our labour law system can't describe those workers as protected by one means or another, there's a clear defect in it. There are various ways to get to that point. They don't all turn upon the definition of worker or the use of a substitution clause to get you outside the scope of the current law. In some cases and in some countries, independent contractors are protected by labour law rights, even if they don't count as employees. In our own past, home workers who might have employed other people had legal rights under labour laws. So this, of course, issue absolutely has to be addressed. I understand it's out for consultation. The measures contained in the bill, many of them would not be effective, unfortunately, if this issue wasn't grappled with.
I think in the situation that you just described, I think part of the driver for the use of substitution clauses is that they're used to avoid employment status. Yeah. So I think in any review of employment status, a key thing that will need to be addressed is addressing the problem of substitution clauses as a way of avoiding either employee or worker status. And there's quite a simple way to do that, which is to treat personal work as an indicative rather than a conclusive factor, because then it just drops back into the range of things that the tribunal will look at. In a situation where a large company is relying on willful blindness to avoid responsibilities under migration rules or under health and safety legislation, there's a very simple response to that, which is to impose criminal liability on large corporations that try to rely on willful blindness in order to avoid obligations in primary legislation. And I think that's just a very straightforward way of tackling an abusive avoidance of rules that are very important to enforce.
Reachable.
You mentioned where the bill places the UK internationally in terms of strike law, and I wondered if you can say where you think the bill more broadly places the UK compared to other developed nations when it comes to the level of employment rights.
Well, if we take the whole of individual employment law then, for example, the bill would bring us closer to, let's say, the OECD average. But there will still be various respects in which we would not be as protective of individual rights as other countries are, especially when it relates to remedies for unfair dismissal. Enforcement could be made much more effective, but there's no doubt that this brings us closer to, let's say, the OECD norm. And not just there, there are many countries in East Asia and other parts of the world which are going to have labour law systems which are at least as protective as ours. So it's a corrective. On the other hand, I'd like to just emphasise that UK employment law has never been as deregulatory as US law, for example, has. So we're not in a situation as US unions and US workers are of starting from scratch. And we also have a history of labour law that we can build on. So that makes it easier, I think, to think of this as the first step in a rolling programme that would effectively restore us to where we were before the 1980s. In the 1970s, over 80% of workers in this country were covered by a collective agreement. Union membership was around 55 or even 60%, but coverage was over 80%. And we had a very progressive employment protection law at that point. Going back further, we were the first country not just to industrialise, but the first country in the world to have modern factory legislation. And the implementation of the Factory Acts, we now know, led to not just protection and things like the weekend and things like that, but also improved productivity. This history is important, I think, for us.
Thank you.
This bill only seems as radical as it appears because the baseline is so low, and I think it's very important to keep that in view. So if you look at the OECD countries, let's assume this bill isn't enacted. We are the fifth least regulated on dismissal protection out of 38 countries. And we are the third least regulated on hiring on temporary contracts. That's where we are in OECD terms currently. So the measures on dismissal protections and guaranteed hours will push the UK back into an intermediate position in the OECD. I don't think this bill marks any kind of revolution just yet. It just pushes the UK back into the mainstream of other civilised OECD countries with employment regulation that works effectively.
And just to return to the point about enforcement, I think the challenges of enforcement, both individual and collective in the UK at the moment, really do add extra difficulty to the, not only do the rights not exist in general, but there are relatively few rights in general. They're very difficult to enforce as well. So,
Chris Law.
Thank you, Chair. We've already heard from each of you about what you'd like to see ideally within the legislation, but one of the things we've heard is either going too fast or too slow for businesses. I wonder what your own thoughts are on how much time is going to be required for businesses as well as employees to be ready for this legislation.
I think clearly there will be a period of adjustment. I think the CIPD, which represents HR specialists in the UK, has indicated that a period of 12 to 18 months would probably be a sensible adjustment period. Businesses in the UK, managers in the UK, tend to want to conform to whatever employment rights and regulation there is. I think the challenge is communication, and it's communicating clearly in a way that then allows them to access knowledge, skills, training, development for their own capacity to do those things. So it will take time, it always does, but the general trend over certainly my lifetime has been where new rights have been introduced in this kind of area, most UK companies want to come into line as promptly as they reasonably can. So we're talking not decades.
Yeah. I think it would be really important to build a consensus on this issue, because what can be achieved in this bill will begin a process which will have to be rolled out further if we're to have a modern system of labour market regulation. And that will require a cross-party consensus, I think. I very much hope that will be possible.
Thank you very much. I'm sorry we haven't got time for any more contributions, but thank you for your attendance. Can't hear. Can't hear.
Bristol needs to leave for an hour. He's asking if that's okay.
You can. People are free to come and go as they wish. Okay. Except me, perhaps. Good afternoon. Thank you very much for coming along. Would each of you like to introduce yourself, please?
My name's Luke Johnson. I've been an entrepreneur and investor for the best part of 40 years. And I currently am the co-owner and the director of various businesses employing roughly 10,000 people.
Thank you. Ms. Lorimer.
Michael Lorimer. I'm the Chief Executive of DCS Group. We employ about 600 people. We're in the fast-moving consumer goods sector. So we have clients, well, the world's biggest non-food clients. So when you go and buy shampoo or a shower gel or Fairy Liquid from a convenience store or a discount retailer, we've probably distributed it and indeed made some of it, because we have a manufacturing division as well, which is quite unusual, I think, for a distribution business to actually invent a manufacturing business in the last 10 years. So, based in Oxfordshire and Redditch.
Thank you. Greg Smith.
Thank you, Sir Christopher. Good afternoon, gentlemen. This is a far-reaching bill. We've heard from the government, we've heard from other witnesses that it's potentially a £5 billion cost to the economy associated with it. Others have suggested that might even be a small c conservative estimate. What is, from the perspective of your business interests, the likely impact economically of this bill on the bottom line as well as overall job numbers in the economy? Mr. Johnson?
I think you need to put it in context. So I would say that in my various decades of creating businesses or jobs, that we now have among the highest ever level of tax burden and highest ever level of overall regulation and legislation. And this is a high-cost country. Job vacancies have been falling for at least 15 months. Unemployment is going up. Interest rates are massively higher than they used to be. Insolvency specialists tell me they are rubbing their hands because they think next year will be very busy. And I would say that even if perhaps we don't suffer a technical recession next year, it's odds on there will be a serious slowdown. And I'm at the cutting edge of businesses. And in some cases, some of my companies might not survive next year. And I don't know how many of the committee members have ever been involved in starting and growing and keeping a company from failing. It's not much fun. And the idea that now is a good moment for small and medium-sized businesses, which, let's face it, are the future. They're the ones that disproportionately innovate. They're the ones that actually disproportionately create most of the jobs. They're the ones that are the next big business. Every business started as a small business once. And the idea that companies that can barely afford any form of HR could stomach a big new bill of 150 pages and 28 measures, they won't even have time to read it. The idea that they can adopt something like this when they are facing quite possibly, you've got to remember they've got the hangover of 2 years when so many of them were shut. They have the legacy debts. They had energy prices. Electricity prices in this country are the highest of any developed nation. Try manufacturing things here now. And the timing of this, I think, is sort of beyond belief, really. And I think that needs to be put into context. So whether I could say whether 5 billion is the real cost or not, it's death by 1,000 cuts. Yeah. Because you never know until you get a big tribunal what the real cost is, for example.
I agree, and I think one of the things, to put it, obviously a bill like this doesn't exist in splendid isolation if you're running a business. Luke has identified the increased costs of doing business, which are severe and which do impact small to medium-sized enterprises, most of which, as you will be aware, represents 80% of the employment in this country. So the news yesterday of the white paper on getting Britain working as a top line, I'm very supportive of. I think it's absolutely brilliant. Getting 2.8 million people back into work is something I'm quite passionate about, in fact very passionate about. In the local area in which we work, in Banbury, we're right beside an area of quite a bit of deprivation, a lot of people on benefits, a lot of young people who are feeling quite depressed about life, and we'd love to be offering those people, I cannot emphasise enough, love to be offering those people jobs. 6 months of the year we do have temporary staff coming in, and we're very glad they come. They come from different countries, they work very hard, they do great work for us. But my concern is, without being able to give you a number on it, is that some of those riskier hires that might come from the areas around where our business is based, in other words, NEETs or kids who haven't worked or people who've been unemployed for a long time, you hear it on the radio every day, people in their 50s can't get a job, businesses will be very slow to take a risk because of the day one legislation that is coming down the track. And I think for us, we have an HR department, we can deal with it to some extent, but as you slide down the road a bit and find businesses that employ maybe less than 20 or 10 people, there will be deep concerns and perceptions that this is just too expensive and scary. And so I think I was encouraged, hugely encouraged by the white paper. I think the top line aspirations of that are absolutely the right ones. It's the same direction of travel that the Jobs Foundation have published a report on this week, 2 million jobs. CSJ are focused on it. I would exhort all of you politicians, regardless of your colour, to get behind the concept of getting Britain working. But my fear is this torpedoes a lot of those plans. Genuinely, that is my fear.
So in the modelling you've both done within your own businesses, and I certainly recognise the picture you paint of Banbury, it's very close to my own constituency. Yeah. I'm sure you've got people from Buckinghamshire on your payroll. What modelling and projections have you done that on the presumption the provisions of this bill do become law and attain royal assent at some point next year on employment numbers in your businesses?
Well, go ahead, Luke. Yes, please.
We're still grappling with the fallout from the budget. Millions of pounds of additional tax that some of my companies are going to have to pay. 6.7% increase in national living wage when average inflation is 2 or 3%. The idea that many businesses have already given deep thought to this new piece of 150-page legislation when we already obviously have things like the Employment Rights Act, the Equality Act, the Health and Safety at Work Act, and many, many other pieces of legislation. I dare say large companies have given it some thought, but most of the businesses I'm involved with are not quite so big. And I think it's, they will wait and see what the actual final result is to try and measure precisely whether it's leaves the business smaller. And I think also you always have to remember with any piece of legislation like this, it isn't just the current jobs, it's the unseen. It's the jobs that were never created, the opportunities. And I urge you to look at the fact that for the first time, I think, in many years, the number of businesses being created in this country has been falling or stagnant for 5 years. That's more or less the first time in decades. And if we lose the full employment we've enjoyed and the enterprise economy that I think we've managed to create, and I believe it to be much more fragile than some might believe, then it will be incredibly hard to get it back. Jobs don't just fall from the sky. They appear because companies are created by risk takers, and they take a risk with every job they create. And jobs only exist because they are helping that business to progress. And 80% of the jobs are nothing to do with the government, they're the private sector. If you crush the private sector, you crush jobs. All the research shows that the single most important ingredient for a happy society are jobs. Without jobs, you don't have civilization.
Yeah, Greg, we have made our turnover is in the public domain, so I can share it with you. We'll probably turn over about £370 million this year. We're in a high turnover, very low, tight margin business. So if we make £10 million net, that's about the height of it. The increased cost of NIC, NLW, and making some provision, which is very difficult to do around the cost of this because not all of it is clear yet, will be somewhere between 1.5 and 1.8 million. So that's, quite a big chunk out of our net profit. We don't have a huge problem with it. We're a company that believes strongly in in creating prosperity. So national living wage is something that our hearts have no problem with because we like to see people getting paid correctly. But we have to mitigate that. That's something that we just have to get on with. Our company has grown successively every year since it started 30 years ago, both in terms of top line, bottom line, and people numbers. And I need to stress again to you, the passion that we have is growth and job creation. And when we see people coming into the business and working their way through the business and earning more money and developing careers and actually prospering, that's what brings us the greatest joy of all. And my concern, and I have to repeat it again, is that smaller businesses than ours, which we, to Luke's point, at one stage were a small business, are going to find it very hard to get on that growth trajectory.
Minister. Thank you, Christopher. Good afternoon. We've heard from a number of witnesses, including many from the business community, welcoming the intentions behind the bill, which is to increase workplace protections. Do you feel the current employment law landscape is too favourable to employees, too difficult for employees, or is it about right?
From my perspective, I think there's a pretty good balance at the minute between employer and employee. I'm sure you could unpick that, and equally there could be cases for either side. But as somebody who runs a business in quote unquote the fast-moving, and in fact Luke Johnson's business is much faster-moving even than ours, but in a fast-moving environment where you are focusing on driving your business and trying to get results, I do think actually there's a good balance at the minute, and not particularly in favour of really tinkering too much with it, is my personal view.
I would slightly differ in that I think some areas are increasingly onerous for employers, and I think increasingly when I talk to entrepreneurs, they are looking to outsource or offshore or automate and not employ people. Not all of that is legislation and regulation. I think that post-furlough lockdowns, there is a vast amount of talk amongst employers and owners of businesses of workforce motivation. And I think it refers to one of the points Michael made earlier about the number of people actually, not in work, of working age and able-bodied. So I think this is an issue for society as a whole. And I think a happy society is one where people are productively occupied. I'm surprised that you say that many employers want greater protections for their staff. They're very entitled to give them to them if they want to. They don't need to rely on the government for that. They can just give them better contracts if they want to. I think that there are a number of concerning specific aspects to this bill which could, as I say, be counterproductive if the objective is to have higher living standards. And as I understand it, this government's priority is wealth creation and prosperity and jobs. I think ultimately, overall, although this legislation won't be devastating, I believe, to employers, I think it will be damaging for job creation, and therefore I think it will be counterproductive to wealth creation and higher standards of living.
Okay, thank you.
Sarah Gibson.
Thank you, Christopher. I must say I'm very glad to hear that you share my concerns for SMEs, and as you've probably all noticed, and it is in my declaration of interest, I have run a small business both here and in the continent most of my adult life. So I feel for them, and it was the first thing that came up once I started to read the bill. And I also noticed that you mentioned that you're concerned about day one rights, and I wondered about changes in the probation period. And it seemed to be an agreement here that it might affect where you draw your prospective employees from. And I'm just wondering whether there are any amendments that you might suggest to the Employment Rights Bill as we go through that you would like to see included that you think might encourage these entrepreneurial small businesses that we so rely on to continue to take on staff from areas of deprivation or long-term unemployed, or those areas that currently struggle to get work.
I was at a breakfast yesterday morning, and it was the launch of the Jobs Foundation's 2 million report, and a chap spoke from Sheffield who runs a business or an organisation that gets young people into work. And he gave the example of this kid, I can't remember his name, who really normally wouldn't find it easy to get a job interview, and they trained him and they helped him to get the right attire and to get him into a job. And the point he was making was he looked very risky. You know, he hadn't worked. He came from a long line of people who hadn't really seen any value in work. But he got the job because the people who were interviewing saw something in this guy that they thought was really worth working with. They knew they were taking a risk. They did. He's turned out to be an absolutely superb kid and is now progressing well through. Equally, yesterday I spoke to a friend of mine, a CEO of a business, who had somebody who interviewed incredibly well and did very well for the first 12 months, got promoted, and at about month 13 or 14 became an absolute monster to manage, and they were able, under the 2-year rights, to be able to sort that out. So my concern is, if you go back to the interview stage, as we all know, you can get that right or wrong in terms of hires. And for SMEs, you just need to give as much comfort and space for them to be able to hopefully get the right hires. But if they do get the wrong hires and it isn't the right fit, that there's an escape route. And I personally don't want to put a time on that. Our system works well for us at the minute, but I'm sure Luke might have an opinion on that.
Yeah, I find this big piece of, by my standards, big piece, 150 pages, that's a big piece of legislation. It's probably what you're used to, but I think if you're running a business and you've got 1,000 other things to do, reading a 150-page piece of legislation about employment, and I find the whole thing rather surprised because I quote the Prime Minister saying he wants to rip up bureaucracy that blocks investment. If there is a genuine belief amongst the government that this legislation will boost investment, then I have a bridge to sell you.
Okay. Who's next? Lawrence Turner.
Thank you very much, Chair, and I do apologise to the panel for returning to an earlier dispute in this quite disjointed way, but just for the record, earlier this week, one of our witnesses, Paul Novak, said, "I do not think there's a direct link. You do not pass a piece of legislation on trade union membership and collective bargaining go up. And our other witness, Mick Lynch, said that personally he hoped to see 50% collective bargaining coverage. That's compared to 39%. Now it seems like thin margarine to me, and certainly not a unionisation of the economy, but there we go. My question to the panel is the same question that was put to employers' federations earlier this week, which is, I think we all understand the points that you have made, but are there specific measures within this bill that you do welcome?
No.
No. I'm not trying to be contrary. I think Luke's point is a very good one. 150 pages, 28 or whatever it is, new measures. It's just apart from anything else, it's an administration burden. And I welcome the white paper hugely, but there's nothing in here I'm excited about.
I'll give you one example of one very specific issue that may arise to do with this that I don't think has been thought through properly, and it's unintended consequences. So there's an adjustment to collective redundancy rights, and this would, I guess, normally apply in a business that is going through a very severe restructuring and possibly an insolvency. Now, what happens in an insolvency is that a buyer can keep that business alive and keep a chunk of the jobs at least going through buying it out of administration. And the one thing that goes through an administration is the 2p rights of the employees. If you are only buying a small portion of that business, normally you can carve out only 2p rights relating to the staff of the bit you're buying. Say it's several divisions or departments or whatever. As I understand it, this will tighten that, as proposed, such that almost any buyer of any part of that business will face the 2p rights of the whole workforce. The unintended consequence, therefore, will be that parts of a business that could survive, that were good, will not. They will be shut. So the whole thing will be shut and all the jobs will be lost. And whoever drew up that part of the legislation, I don't think has fully thought it through, because it's in society's interest that where businesses can be saved and rescued, and I've been involved both sides in situations like that, then they should be, because it's always a great deal easier in certain respects to save a business that has failed because it had too much debt or some other problem than starting all over again from scratch.
Perhaps I should just add that there are aspects of it that I'm quite neutral or comfortable about. And there's some things around, bereavement, etc., which are all good. I should emphasise really that my focus today is around the day one stuff and flexibility.
Nick Timothy.
Thank you, Sir Christopher. I think it's quite conspicuous that you're the first two witnesses, I think, who actually run businesses yourselves. Yes. And your evidence is rather different to much of...
Have any of the other witnesses ever created a single job?
I'd have to leave that to them.
Well, I did think, Nick, we could have met in the Natural History Museum in the endangered species part of it as business leaders, but never mind.
Indeed. And with not just this bill, but with the increase in employers' national insurance contributions, things like the equalisation of the national living wage for young people. I think you also mentioned, Mr. Johnson, you mentioned energy prices, which are a particular concern of mine. You sound very worried about the future of innovation, investment, and ultimately jobs in this country. You have a platform today to send a message to the Prime Minister and to all the ministers who are involved in this legislation. So what would that message be?
I think there is a complacency about our current prosperity. I think that, there is this belief that jobs will always appear, that businesses will always invest, that living standards will naturally rise. I think it sometimes feels as if Britain is a nation running on fumes at the moment, and that we have large amounts of debt, certainly government levels. We have public spending taking, I think, or projected to take 45% of GDP, a very high level compared to what it was 10 years ago. That crowds out the private sector. As I said earlier, actually interest rates, especially if you have to borrow from the bank, are pretty punitive. The idea that we can continue to occupy the role we used to decades ago in the world, it's a dramatically more competitive place. There are dozens and dozens of more countries where money can invest and factories can be sited and jobs created. And many of them are much lower cost than we are. And they might argue they have, a hungrier workforce or whatever it may be. And if we regulate, no country has ever taxed and regulated its way to a higher standard of living. It feels as if that's what this government is about. And, they need to get real about how prosperous economies are actually created.
Yeah. I would say, if I was speaking to him, listen well to those who matter most. So, back to the white paper, you simply cannot create jobs without the private sector being on board. You can listen to all sorts of people who will give incredibly important stakeholder advice to you, but if you want to create jobs, if you want to grow the economy, the business community has to be on board. And if we want to create prosperity, the private sector is where it's going to happen. So I would say listen well to those who matter most. And I would say, secondly, take your time and consult widely on this, because I feel at the minute the consultation is not wide enough. We're here today, there's two of us speaking broadly on the same message. But take time, don't rush it through for the sake of trying to get a time scale met. Take time, speak to business, go out to the country and speak to the small and the medium-sized and the employer groups, because a lot of this stuff isn't controversial and a lot of it is is reinforcing, I think, to the first question, a lot of stuff we do in the business anyway. We've 600 employees. At the minute, I think we've 3 people total on long-term sick. So we don't have a lot of problems. We've got an engaged workforce. We are delighted to pay people well, above the national living wage. All of that stuff is about us trying to help people, not only our people prosper, our customers, and the Banbury community prosper, but it feels quite counterproductive and could have a lot of unforeseen consequences.
Michael Wheeler.
Thank you, Chair. So we've heard, as the Minister said, from businesses and their representative groups that said that good employers have nothing to fear from the measures in this bill, and in fact they welcome the level playing field to prevent undercutting. Given the purpose of this bill is to promote good quality employment, what specific measures in the bill do you think don't contribute to that aim?
Well, it's already been raised that I think if you introduce lots of rights like paternity rights and flexible working rights from day one, you risk having more problems, and that will be a cost. For example, there's a new obligation to protect employees from harassment. I think that sounds wonderful, but if, for example, you're in the licensed trade, as I am, that means that a single remark from a single customer could lead to a harassment claim for which you're responsible. How are we on earth going to police that? And I don't know whether you're at all familiar with the state of the hospitality trade, but it's pretty dismal. We had 2 years where we were barely allowed to open. We've had unprecedented energy costs. We have higher rates. We obviously have all the other NIC and so forth costs from the budget. And we have at best flat, if not declining, sales. And I fear that hundreds, if not thousands, more hospitality businesses will shut next year for good. That isn't obviously the fault of this legislation, but it's, petrol on the flames. And I suspect a lot of the organisations you're hearing from are very large corporates who have huge HR departments, and in a way, they want to keep out new, young, innovative competition, because that's how big companies often behave. And so building walls of regulation suit them. But that isn't how you get a growing, vibrant and innovative economy. You get that through lots of smaller, younger businesses growing and coming up with new ideas and challenging the incumbents.
Repeat the question again, Michael, please.
Do you want the specific bit at the end?
Just the end, yeah.
So, given the purpose of the bill is to promote good quality employment, what specific measures in it do you think don't contribute to that aim?
I think it's back to this what Luke's already said, a lot of this day one stuff. Now that, I don't want to paint a picture that we don't do a lot of this stuff already, because if we work on the basis that if you recruit well and train and develop well, actually you don't have as many problems down the line. But I think it's easy for us, because we have an HR department and we have legal advice, that if we do hit the buffers, we can deal with that. The perception, which of course is always stronger than reality for smaller businesses, that, you know, entrepreneurial businesses that Luke mentions, is I think it will create a lot of fear and concern. I was in a shop recently and it took a long time to pay for a pair of Bunnington boots, and I said, why is it, what, are you busy? And he said, no, but so-and-so left and we're just not replacing him because we're very fearful. Small business, 2 or 3 employees, we're anxious about what's coming down the line. So I think, yeah, you just need to be very mindful, and this is where this consultation piece comes, wide, speaking to people and seeing where some of the sore points are going to be.
I'm afraid that brings us to the end of this evidence session, because we are not allowed to go on beyond 22. So can I thank you both very much for sharing with us your knowledge and experience based upon your work as employers.
Thank you, everybody. Appreciate it. Thank you.
We now come to the next panel. What are we going to do about it? We don't seem to be able to get Mr. Darling, do we? No, really. That was exemplary. I think that needs to be put on YouTube and distributed.
I've already told them to do that.
Oh, have you? Okay, sorry. Okay. You're always ahead of the game. Good afternoon. Thank you for coming along. And can I ask you both to introduce yourselves briefly?
Thank you, Sir Christopher. I'm John Kirkpatrick. I'm Chief Executive of the Equality and Human Rights Commission, which, as I'm sure colleagues know, is the regulator and enforcer of the Equality Act and one of the UK's national human rights institutions.
And I am Margaret Beels. I am the Director of Labour Market Enforcement, and I'm aware that people are not always familiar with what the Director of Labour Market Enforcement does. My role was created in 2016 by the Conservative government, who perceived that there was a lack of joined-up thinking between different enforcement bodies, and they perceived that it would be assisted by creating the role of the Director of Labour Market Enforcement to create a strategy to apply to 3 of the bodies who have an important role in enforcement, being the National Minimum Wage Team, the Employment Agency Standards Inspectorate, and the Gangmasters and Labour Abuse Authority. So I have a statutory responsibility under the Immigration Act 2016 to produce a strategy that covers the activities of those 3 bodies, and I also have a statutory responsibility to report on whether the strategies that I have said have made a blind bit of difference to what has gone on. So I most recently...
So I think that's enough. Perhaps if you've got more to say, you'll be able to bring it out in answer to questions. Yep. Greg Smith.
Thank you, Sir Christopher. A straightforward question that will probably have some debate amongst it. Clearly, to the Equality and Human Rights Commission, impact assessments on any bit of legislation are hugely important. So can I ask, who's right, the government or the Regulatory Policy Committee in their condemnation of the impact assessments?
I'm not sure you'd necessarily expect me to answer that question directly, Mr. Smith. Nevertheless, I suppose what I would say is that, yes, you are quite right. Impact assessments are very important to us. Let me say a little bit more about it in the context of this bill, particularly if I take some of the provisions designed to improve opportunity and to regulate particular forms of contract, for example. We know from our work that, for example, women and disabled people have lower rates of employment than men and able-bodied people. We know that younger workers are more likely to be in zero-hours contracts than workers of other different ages, and so on and so forth. So the measures that are in this bill designed to protect the interests of those people with protected characteristics may well be beneficial to them. but not if the result is that those jobs then vanish rather than be improved. So the question I'm afraid I would pose back to this committee and potentially to the government is the real importance of assessing up front the likely implications of those of the measures that it wants to put in place, and then of course subsequently, if Parliament does enact them, reviewing them and monitoring them subsequently so as to see what impact they've actually had, because that would be really important to knowing whether they've been impactful or not. And I should probably put in my advertisement at the end of that it seems to us that only if it does that will the government particularly be fulfilling its obligations under the public sector equality duty to assess the impact of the things it wants to do on those in whose interests it is seeking to act.
I would address it in a similar but not the same way, in the sense that when we look at the labour market, we see the job situation being very described as we have a very flexible labour market, but one person's flexibility can be another person's precariousness. And we're about to publish some research, in fact, tomorrow, that is based on a survey of workers that is demonstrating that about 10% of workers are in precarious work. And of that, 8% of those get stuck in precarious work. And that is a matter that does need to be addressed.
So I appreciate from the Department of Business and Trade's perspective, it might be more a clear-cut answer, but Mr. Kirkpatrick, from your perspective, do you think there is actually a high risk, given your answer earlier, that the measures contained in this bill could actually decrease the number of jobs in the UK economy?
I think the answer is it's very hard to tell. And you have already. I've heard some of it this afternoon, and you've had it in other sessions. You've heard evidence on that from others who are arguably better qualified to answer that question than I would be. I think, as I say, my encouragement to you as a committee would be to encourage the government to make sure it thinks that through very carefully as you think about this bill, and to bear that advice in mind as you're scrutinising it.
My office has not done that analysis, and I would be guessing if I answered the question.
Thank you.
Minister.
Good afternoon. Could I just ask you, Margaret, particularly about your views on how the Fair Work Agency might help in the enforcement landscape in the future?
I took on this role in the expectation that there was going to be a single enforcement body, which the previous government had referred to, but in fact did not bring about. And I was strongly supportive of the creation of a single body, and accordingly I am supportive of the creation of the Fair Work Agency, looking at, from my perspective, about what has worked under the existing arrangements and what could work better. I went back and looked at the recommendations in the strategy which I've most recently published on the 11th of November. And that had 12 recommendations in it, and I looked at them and looked at how it is working out now under 3 bodies with different governance, with different plans, with different ways of doing things, and whether I think that under a Fair Work Agency regime those things would be done better. And looking at them and a fairly quick assessment, I would say half of them would definitely be done better. Others probably would be done much the same. But the ones that relate to better joined-up approach, to greater efficiency, to better sharing of information amongst themselves, those are the things that I think the Fair Work Agency will do a lot better.
Would you be able to give us some examples of the sort of areas or issues that might benefit in that way?
I think that one of the things that I found it hard to do is assess the impact of the different bodies, because they all have their own governance arrangements. I have a statutory responsibility to decide whether more should be spent in one body or another. But in practice, because they run under their own governance, it's really hard to do that and see whether spending a bit more on national minimum wage enforcement or a bit less on employment agency, whether that would be better value for money, because value for money for the public purse is really important. All of us are public servants. We are all accountable to you as parliamentarians and to the public. And I think that I have found it really difficult to answer that question about what the effectiveness of the different activities.
Okay, thank you. A question for both of you now. Do you feel that this bill and the Fair Work Agency in particular will help protect people with protected characteristics at work?
Well, it's very clear, Minister, that that there are a number of people with protected characteristics who are particularly vulnerable to the sorts of practices or exploitation that the Fair Work Agency would be devoting itself to be concerned about. I'd defer to Margaret on whether the unification of the existing authorities will make for improved enforcement. If it does, then it will clearly be of benefit to those people. I suppose the one thing I would add is that it's really important in this kind of area and in these parts of the labour market that there is clarity both on what employers' obligations and employees' rights are, and what their sources of redress and so forth, if those rights are breached, might be. So real clarity and distinction of who enforces what seems to me very important. There's no difference between us on this, nor I think anything in the bill that would confuse that. But the maintenance of that clarity, so that people can understand what their rights are and how to exercise them, it seems to us an important precondition to the bill being successful in that aim.
The research I referred to that's being published tomorrow demonstrates that the workers that are more at risk of precarious work are female workers and younger workers, also workers from a lower working class background. And the industries that they work in that are most at risk of precarious work are the hospitality industry, the retail, agriculture and construction. And so I think that to the extent that the bill will address some of the issues that are affecting more precarious workers, then that will be of benefit.
Sarah Gibson.
Thank you. Well, we've had quite a few previous witnesses that have said that the improved employee rights, and in fact existing employee rights, are often not exercised because the tribunals are slow, they're expensive, they prove expensive both for the employee and for both sides. And in fact, they are considerably, we have poorer enforcement than most of our OECD colleagues across the world. So do you think that, this is particularly true for industries, as you've just highlighted, that are not necessarily unionised, so hospitality or such like. Are there any sort of specific areas of the bill that you think could be simplified? Because obviously there are other things that are outside of the remit of the bill that we've been discussing. But within the bill itself, are there any sort of specific areas that if they were simplified, they'd make it easier and more effective for enforcement?
I have responsibility for the national minimum wage team. And when I talk to them about what they do, they very often refer to the fact that the complaints that come to them are not valid, that they are made without a full understanding by the workers what their rights are in terms of national minimum wage. And they talk about training their inspectors for 6 months. And it troubles me that is an area where it is difficult to know whether or not you're being paid correctly. And so, from my point of view, what I would favour are arrangements that are better at communicating with workers as to what their rights are. I know ACAS does a brilliant job, and the National Minimum Wage team themselves and the other agencies all try and better communicate. But I think there is an issue. If the national minimum wage, if you pay a worker the national minimum wage, the chances are they're not being paid the national minimum wage. because it's just because it is a fine. So the to play safe, then businesses should be paying comfortably above it in order to make sure that they're okay.
I don't have a huge amount to add to that. I mean, I think I recognise that most Equality Act enforcement comes through the tribunal system. That does impose a burden on the individual to understand their rights, to have access to appropriate advice, to be able to access redress, and so on and so forth. We can do a certain amount of enforcement ourselves. The other thing that we do is that we will do as an enforcer of the enforcer of the Equality Act is try and provide such clarity of guidance as we can. In a sense, it's the first step in an enforcement process. The most recent example, I suppose, would be the guidance that we consulted on and published on the Worker Protection Act, which came into force only a few weeks ago, where we felt it desirable and necessary to put quite a lot more guidance into the public domain there to help both employers and employees understand their rights. And I think that, in a sense, the lesson from that is, yes, that imposes that this is something that we kind of own the responsibility of doing in our area of work, I'm sure, and others do in others. As Margaret said, ACAS do work on this, as do others as well. But the really important thing is that the initial law is as clear and straightforward as it can be, and I would urge the committee to have that in mind as it's thinking about the legislation in front of it, that the clarity and simplicity of the underlying law is the thing that makes it easier to enforce.
Chris Barry.
Thank you, Chair. Mark, I've got a question for you specifically about the Gang Master and Labour Abuse Authority. Because it strikes me that a lot of the discussion we're talking about are about things like 0 hours contracts and wage enforcement, but actually the GLAA deals with quite a different set of labour market challenges, either very excluded groups or very isolated groups like shellfish workers or the victims of modern slavery. And you know, it is a first responder to the NRM, so it's got a different set of responsibilities. I suppose my first question is, what's your assessment of how effective the GLAA has been in terms of how it was constructed and how able it has been to perform its functions? And then secondly, how do you see those functions specifically around modern slavery and on those kind of, you know, thinking about who it was set up to protect, people like the Morecambe Bay cockle workers. How do you see those functions in a single enforcement body?
I think it's really important that in setting up the new body, the three bodies sit down and think, what do they do well? And so that we can, when we bring them together, we will bring the best of what is done. And in fact, one of the recommendations in my most recent strategy is encouraging them to start the dialogue with each other at every level, so that if, for example, when an inspector goes out from the Employment Agency Standards Inspector, what do they do versus what is done when a compliance inspector goes out from the GLAA? And I gather a lot of evidence from stakeholders, and they talk about this works really well here or that works really well there. And so I think that in forming the Fair Work Agency, there shouldn't be a presumption that it'll always be done one way because that's done by this lot, but we should actually look at the journey of non-compliance, because it's important to help businesses be compliant. That is by far the best way of achieving compliance. So who is good at doing the communication with businesses, and the National Minimum Wage team do that as well. They have their geographical compliance approach. They go out and try and help business. So how do we build that into the structure of what is done? When you're coming to deliberate non-compliance and modern slavery, you need to have the teeth in order to do that. And the modern slavery dimension will be moving across into the Fair Work Agency. But then we'll have the whole spectrum, but looking at how things are done. Now, resources is going to be really important for the Fair Work Agency. All of the bodies would talk about the fact that they don't have the resources that they would like to do the full job that they are there to do. I go back and I challenge them and say, well, can you show me the value for money in what you're doing? are you being as efficient as you might be? My strategy talks about use of artificial intelligence. Are they building those tools into how they do things so that they can be the maximum efficiency as possible? And are they, and then as they are coming together, are they going to listen to each other to make sure that they pick the best?
Anybody else? No?
Could I follow up?
Okay, so we've now got Steve Darling.
Mr. Chair. I'd like to. I've experienced a conversation with sixth formers in Torbay who've been sexually harassed in the workplace. I would welcome your thoughts on how the bill could be strengthened so that it is supportive to employers in supporting these people who are experiencing this situation. Thank you.
Shall I start on that one? I mean, we start from the position that everybody has the right to a workplace in which they are free from the risk of discrimination or harassment. That should, in our view, ought to be the way it works. We have lots of evidence, as you do, and I'm sure other members in their experience of constituents. For example, from our Turning the Tables report, a quarter of respondents have been harassed by third parties in the workplace. A particular issue for people in customer-facing roles. Interestingly to hear, Margaret, when you were talking about sectors that are vulnerable to exploitation, some of the ones where we have found vulnerability to...
Don't worry about the bell.
I was going to say, I'll carry on as long as I'm audible, Christopher. We have found similar sectors where people are vulnerable and, for example, have issued specific guidance, often in combination with relevant trade associations in sectors like hospitality and indeed performing arts, where there have been which appear to be particularly prone to instances of sexual harassment in particular. So I think our general position, and we continue to do a lot of work on this. We have active enforcement activity, for example, with McDonald's, and announced only today with the Welsh Rugby Union, who, as some of you will be aware, have had their difficulties in this area, but have agreed with us a Section 23 agreement, as we call it, to rectify what's going on. So I think it's really important. I mean, we are broadly comfortable with the provisions in the bill. That strengthen the sanctions on sexual harassment. We know that we are responsible for enforcing some of those that already exist. We are concerned that the scale of that enforcement will be challenging for us, and that we, as Margaret said earlier about resources, will need the capacity to be able to do what we can to help enforce the measures that Parliament puts in place.
Yes?
I would only add to that I'm well aware from the evidence that comes to me that vulnerable workers, one of the things that they also experience is sexual harassment, and they're so desperate to keep their jobs that they will accept that because it's the price of getting the next shift, and that's unacceptable.
Uma Kumaran.
Thank you, Chair. Thank you, John and Margaret, for the important work that you both do in your respective roles. How do you believe that the measures in this bill could improve opportunity for workers of all backgrounds? I'm thinking specifically to class, to race and to disability.
Well, I think I said earlier that, that to the extent that some of those protected characteristic groups have worse experiences in the labour market than others, then protection of them is absolutely desirable. As I say, the only risk is if the flexibility of employment sometimes, which can even include such things as 0 hours contracts, very convenient and desirable for some people. If those opportunities were to diminish, then that would be of some concern. But I think that does no more than repeat the point I made earlier, that actually one needs both in advance and subsequently to make sure that we monitor very carefully the impact of these measures and on both levels of employment and the quality of employment, as it were, which is what I think they're aimed to do. You might want to add to that.
When we look at the sectors that we regard as the highest risk of labour exploitation, which is what I worry about, agriculture, the car washing industry, construction, adult social care. I don't think we've talked much about adult social care, but I've been doing quite a lot of work in relation to the workers' experience in adult social care. And so I welcome there are measures in the bill that will start to address some of these issues. I know that there are going to be problems that the bill addresses that are not necessarily the totality, because there are obviously issues around finance for the improvement in those measures. But I think that previous speakers talked about what we as a nation value. We need to value our adult social care workers and the work that they do, and give them more support.
I suppose I might add, since you've introduced social care as a particular sector, certainly the work that we've done in the past on the workforce in that sector does show, or did show, again, an issue I referred to earlier about the challenge of people being able to understand their rights, particularly where the rights are complicated, they're not necessarily written in the most accessible of language, even in the best of guidance, and that can be really challenging and has been particularly for ethnic minority workers in the health and social care sector, for example, amongst others.
I mean, it was quite striking, the work that I did on adult social care earlier in the years. About a third of domiciliary workers in England are on 0 hours contracts. And that does seem a very high number.
If there are no further questions, may I thank you both for coming along and sharing your expertise with us this afternoon. Thank you.
Thank you.
We can now move on to the next witness, Dr. Mary Ann Stephenson, please. Dr. Stephenson, would you please introduce yourself briefly?
Yes, hi. Thank you very much for inviting me here this afternoon. My name's Mary Ann Stephenson. I'm the director of the UK Women's Budget Group, which is a feminist economics think tank that works to analyse the impact of economic policy on women and men and different groups of women and men.
Thank you. Greg Smith.
Thank you, Sir Christopher. Good afternoon, Doctor. What would be your assessment, given the work you do, as you've just described, that this bill would do for women and men in the workplace?
We think that this bill marks an important step in the right direction to improve the rights of women in the workplace. We particularly welcome the provisions on 0 hours contracts, which will benefit over 500,000 women, changes to statutory sick pay. 73% of those who currently don't qualify for sick pay because they earn too little are women. We welcome the fair pay agreement in social care. I know the previous speakers were talking about social care, and it'd be good to talk a bit more about that. Obviously, women are the majority of workers in the social care sector, but they're also the majority of those needing care, and improving the pay and conditions for social care workers will also have a beneficial impact on the recipients of care, because it will reduce turnover in the sector, which is a really big problem at the moment. And therefore a knock-on impact actually on unpaid carers, the majority of whom are also women. Care is very much a female-dominated sector in all areas. We also welcome the improved right to paternity and parental leave, the day one rights. These are often seen as particularly beneficial to fathers and partners, obviously, but we believe that women will benefit from this. Women's unpaid work is at the heart of their economic inequality. Women do 50% more unpaid work than men. And the time at which a child is born is often the point at which the distribution of unpaid work gets fixed. Most couples go into parenthood thinking that they want to have a more egalitarian sharing of care than maybe their parents did when they were growing up. And as one person described it to me, you wake up one day and you suddenly find yourself back in the 1950s because of the very limited rights that fathers and second parents have. So we think this is a policy that will benefit women as well. We also welcome the greater protection against pregnancy and maternity discrimination. We know you heard from the Fawcett Society and Pregnant Then Screwed around flexible working and sexual harassment earlier this week, and we very much support their positions on that. There are some areas where we would like the bill to go further. On statutory sick pay, for example, we actually think that the government needs to increase the rate of statutory sick pay. Its low rate at the moment means that even those people who are entitled to it often continue to go to work when they're ill, which is not only bad for them, it's bad for public health.
I hesitate to interrupt you, but could you give us an indication of where you think statutory sick pay should sit?
Well, at least to the level of, for example, maternity pay.
Okay.
We are also one of only 4 countries in Europe that doesn't extend some right to sick pay to self-employed people. So we think we should do that. We were disappointed that the government went back on its original proposals to the people who were on previously 0 hours contracts who had shifts cancelled at the last minute should be reimbursed for those shifts. That's a particular problem for women who have to arrange childcare, often if they're in paid work, and so having a shift cancelled doesn't just mean the loss of the pay, it means paying out for childcare. We think that this is a missed opportunity to improve rights to maternity pay. We know that's under review, but particularly to deal with the discrepancy between statutory maternity pay and maternity allowance for people claiming universal credit. So at the moment, statutory sick pay counts as pay for the purposes of universal credit. Maternity allowance counts as a benefit. So you lose universal credit pound for pound if you're not entitled to statutory maternity pay and have to go on maternity allowance. You're losing whatever money you get off the universal credit. We also, again, are supportive of the call from Fawcett Society and Pregnant Then Screwed that there should be a duty to advertise jobs as flexibly. We think that underpinning all of this is the problem with our civil legal system, so that having improved rights at work is only as important as your ability to exercise those rights. And since the reduction to civil legal aid under LASPO in 2012, the only area of employment law that is covered by legal aid is discrimination law. Many people don't even know they have a discrimination case until they see a lawyer in the first place. So actually, if this bill is to have the effect that the government wants, they also need to look at provisions around civil legal aid.
That's a hugely comprehensive answer.
That was a big answer.
Okay. That is a hugely comprehensive answer, and I'm very, very grateful for it. One bit of evidence that I don't think you covered in your list there that we heard earlier in the week was a disappointment from other witnesses that there hasn't been an extension to bereavement leave in the horrible, sad circumstances of a pregnancy loss.
Mm-hmm.
Is that something that is also on your list?
Yes, it is. It is something that we have also called for as well. This is where a woman loses pregnancy before the point at which it counts as a stillbirth. That late pregnancy loss can be extremely traumatic and have health implications for women as well as the psychological implications, and we think the right to paid leave in those circumstances is really important.
That's very helpful, thank you. Minister.
Thank you, Sir Christopher. Good afternoon, Dr. Stephenson. I think the Shadow Minister was right. Your response to the initial question was a comprehensive critique of the bill. Could I just ask you a little bit more about sexual harassment and the issues with that in terms of preventing it and also dealing with third-party harassment? Is that something that you have been concerned about?
We haven't done as much work in this area as, for example, organisations like the Fawcett Society or some of the trade unions have. But we are very conscious that for women working, for example, in the hospitality sector, third-party harassment can be a really serious issue. And we do think it is important that women have those rights and protections. But beyond that, it's more we would support them that we've done much detailed work.
Thank you.
Sarah Gibson.
Thank you. Just quite a quick question. Do you think that the measures in this bill go anywhere in the way of supporting those with family or carer responsibilities?
Well, obviously, some of the provisions around paternity and parental leave as a day one right, that will benefit those with caring responsibilities. We are pleased to see that there will be, there is plans to review carers' entitlement. I mean, the problem with leave for carers is it's one of the lowest paid benefits that we have in the UK. It means that very many carers end up in poverty as a result. We also know that there's high rates of physical and mental health problems among carers because of the poverty, the strains caused by caring, or the difficulties of balancing care work with paid work. Obviously, the flexible work provisions will go a long way to help people with caring responsibilities, and we think that is a very good thing.
Alex McIntyre.
Thanks, Christopher. Dr. Stephenson, one of our previous witnesses, Luke Johnson, said that one of the things that he thought was bad for business in this bill was increasing access to paternity leave. Now, Mr. Johnson publicly backed the now leader of the opposition in her leadership campaign, who of course said that maternity pay had gone too far. Do you think that perhaps in reflecting on your evidence that those comments belong to the 1950s? And do you see the benefits both for business and workers in protecting mums and dads in the workplace?
Yes, I mean, what we know is that at every point in which women's rights have been improved in the labour market, the Sex Discrimination Act, the Equal Pay Act, the introduction of the national minimum wage, which, women were the majority of those who benefited, there have always been some people who've said this will be disastrous for business and it will lead us to stop employing women. And that hasn't actually happened. The proportion of women in the labour market has gone up, and businesses have benefited from having, increased women in the labour market. I actually think that what's proposed around paternity and parental leave is relatively minimal compared to what's available in a number of other European countries, for example. And I don't think that will be disastrous for business. I do think that if we want women to be able to survive and thrive in the labour market, we have to redress the balance where women are seen as much more of a risk, or women of childbearing age are seen as much more of a risk for employers than men are. We know that in the long term, we will all benefit from legislation that makes things better for parents, makes it easier for people to have children and to raise a family, because one of the crises that we're facing on a global scale is actually a falling birth rate. And a society where there aren't enough young people to work and to pay taxes that will support those of us here today when we're in our old age, that will care for us when we're old, is a society that's in trouble. So part of doing that is actually improving rights for parents when they have small children to mean that people actually have the children they want to have rather than think we can't afford to do this.
And Ms. Mitchell.
Thank you, Chair. Thank you, Dr. Stephenson. Just going on from
the last question from what a previous witness said today, who said, I think if you introduce lots of rights like paternity rights and flexible working rights from day one, you risk having more problems and that will be a cost. Just going a bit deeper into your assessment of that, and if you think family leave and flexible working should be viewed as a net cost.
Well, I'm also an employer, and we have an incredibly flexible working policy. I think flexible work is largely beneficial for employers as well as for workers, not least because it enables you to recruit and retain the best staff. Particularly at the moment, the labour market is relatively tight, particularly in some parts of the country, particularly in some sectors, and we have higher levels, for example, of economic inactivity among women than among men, and we know that this is something the government wants to do something about. One of the reasons for economic inactivity among women is because of caring responsibilities, and there's large numbers of women who are not in the labour market who said they would like to be in paid work if they could find a job that gave them the flexibility that they need. And so I think this can only be of benefit to the wider society and ultimately to employers, because A, they can attract the best people, and B, that we're more likely to have a strong and growing economy.
Thank
you, Chair. Thank you, Dr. Stephenson. I'm really proud. My constituency is the home of the Match Girls strike, so the fight for women's rights in the workplace runs deep in the history of my politics. How do you think the measures in this bill will benefit women's workforce participation? And you've talked about some of the kind of broader views, but if there's even one thing in particular that you think is going to mark a real difference, I'd be keen to know that.
Well, as I said, I mean, the flexible working provisions particularly benefit women's labour market participation. Some of it's not just about participation, it's about improved paying conditions. So, for example, the end to exploitative 0 hours contracts, I think, improves women's position in the labour market, which means that they're less likely to leave the labour market. I think that the fair pay agreements in social care, if those were seen as a starting point and that was extended, having started with social care and looked at how that worked, looked at other sectors, for example, early education and childcare is actually a sector that's very, very similar to social care. Particularly now we have the big extension of the funded hours coming in that it's largely private provision delivering public services which are majority publicly funded, where you have majority female workforce on low pay, often part-time. And so I think that model of fair pay agreements, again, could not just support women working in those sectors, but actually support more women into the labour market if you have available, affordable early education and childcare. We did some work with Claire's last year looking at the loss to the economy of women's under-participation compared to men. And that comes to £88.7 billion. So actually enabling women to enter the labour market or stay in the labour market or increase their working hours has the potential to have a real benefit on both the national but also local economies as well.
Alison Hume.
Thank you, Sir Christopher. Dr. Stephenson, I'd like to just ask you a little bit more about the hospitality sector. 20% of all employees in my constituency of Scarborough and Whitby work in that, and obviously a large number will be women. And according to the latest ONS figures, women in part-time jobs were paid, 50% of women in part-time jobs in Scarborough and Whitby were paid below the living wage. Now, can you drill down a little bit more about how the bill will lead to greater income security for women working in hospitality?
Well, I think having a better enforcement body around the national minimum, the living wage, and actually equalising minimum wage rates with living wage rates for workers under 21, because particularly in the hospitality industry, obviously it's a sector that employs large numbers of younger people, and so that will be really important. And I think actually having proper enforcement of the living wage, I mean, good employers want to do the right thing, and they are undercut by bad employers who are deliberately breaking the law. And so I think that better enforcement is important. I mean, I would say, going back to my earlier point, that out with this bill, it's also really important to look at access to proper legal advice for people in those situations. It can be very difficult. We have advice deserts in this country. One of the impacts of cuts to civil legal aid has been a reduction in any lawyer with specialism in certain areas, because the loss of legal aid has meant there's fewer, there's less money in the sector, fewer people go in and develop that specialism, which means that even if you can afford to pay, you can find it quite hard to find a lawyer for certain areas. So yeah, I think the enforcement mechanism will make a big difference, but we also need to look at legal aid.
Marie Sybil.
Thank you, Sir Christopher. So 2 questions from me. Can you reflect, picking up on your point about economic inactivity of women with caring responsibilities, can you reflect on the value of paternity leave and parental leave protections in the bill on women and their own job retention and economic activity? And as part of that, what may need to be, what other opportunities are there in relation to paternity, parental leave to strengthen women's economic activity? And my second question, if I may, we heard earlier that from one of the witnesses that they weren't certain if the bill would lead to a decrease in jobs of people with protected characteristics. I wonder if you can reflect on your perspective on the role of the bill in positively impacting those who themselves have protected characteristics, particularly women and disabled women.
Okay, yes, of course. So on your first point, I mean, as I said earlier, women's unpaid work is at the heart of their economic inequality. And one of the things that we need to do is have a better balance between women and men of those unpaid caring responsibilities. I think the paternity and parental leave changes in this bill are a step. They are a small step. We do need to go much further because we still have one of the biggest gaps between entitlement for fathers and second parents and entitlement to mothers across Europe. And we also need men to have periods of leave in their own right that they are not taking while the mother is on leave. The thing about paternity leave is it's taken immediately after the birth generally, and it's about providing support to a new mother just after she's given birth. You know, it's a very difficult time. The first time you don't know what you're doing, and the second time you've normally got a toddler to look after as well as a baby. You need more than one pair of hands. But if we're going to change patterns of caring, there needs to be provision that would encourage and support men to have leave after their partners have gone back to work, where they are the sole carer. Because it is not until you're the sole carer in charge of a baby that you actually understand what it's really like. If you're one of two parents at all times, there's always somebody else to do it. And so that needs a different type of leave. So we have called for, a period of maternity leave, which is about recovery from childbirth, establishing breastfeeding, so on, a period of paternity partner leave that's about supporting a new mother, and then for both parents to have a period of what we would call parental leave, which is about caring for a child, and both of those need to be paid and they need to be individualised, and we think that would make a difference, and that's something that we would hope would come out of kind of longer term reviews of maternity, paternity and parental leave. In terms of whether the bill would lead to a decrease in jobs for people with protected characteristics, I mean, as I said earlier, this is a warning that is often made when you improve employment rights, that actually it will lead to job losses. That hasn't proved to be the case thus far, and I don't think the changes in this bill are so significant that it would lead to job losses. I think, for example, the changes to paternity leave, for example, are relatively minimal. I mean, it's making it a day one right rather than making people wait. It will really help those for whom it benefits. But I think it would be unusual of an employer to go, oh, actually, men now have a day right to paternity leave, therefore I'm not going to employ them. Because, of course, men have the protected characteristic of sex, just as women do. And I think in many areas, improving the situation of, for example, workers on 0 hours contracts who are more likely to be from ethnic and minority backgrounds, is more likely to improve their overall standard of living, help lift them and their families out of poverty and so on, so it's more likely to be beneficial.
Lawrence Turner.
Thank you very much, Chair. Dr. Stephenson, I'd like to ask about outsourcing and outsourced workers, which is perhaps an often overlooked part of the labour market, and we do know that women and people from ethnic minority backgrounds are more likely to be outsourced. I just wanted to ask your opinion of the clauses in this bill in relation to the extension of gender pay gap reporting to outsourced workers and the restoration of the two-tier code for outsourced workers from the public sector.
So I can speak to the first one. The second one is probably beyond my area of knowledge. I mean, we welcome the move to include outsourced workers in gender pay gap reporting. We think that this has been a gap. We're very, very conscious that you will quite often see the lowest paid workers, particularly, for example, in the public sector, are actually now outsourced. You know, one of the reasons why people say pay in the public sector is better on average than in the private sector isn't because it's better job for job, it's because the lowest paid workers have been moved out of the public sector and into the private sector. And a large proportion of those workers are women, for example, cleaners, canteen cooks and so on. And so counting those workers in, I think, is really important. And I think, anything that encourages the greater kind of insourcing of workers, because what we've seen with outsourcing is the efficiencies and the savings, so-called, that have been made have been largely at the expense of the pay and conditions of those outsourced workers.
If there are no more questions, then can I thank you very much for coming along and giving your evidence. Thank you.
Thank you very much.
We now come to the finale, the Minister. She'd be good to help on Fridays, talking things out. Minister, can you briefly introduce yourself for the record, please?
Yes, good afternoon. My name is Justin Madders. I'm the Minister for Employment Rights, Competition and Markets, and also state for the record, I'm a member of the GMB and Unite Trade Unions.
Greg Smith.
Thank you, Sir Christopher, Minister. Slightly bemused by having a member of the committee also answering questions, and fundamentally many of the things I and my colleagues from the official opposition will be asking you will come in the form of the line-by-line sessions in the coming weeks. But can I briefly ask you about the Regulatory Policy Committee? And I fully appreciate that you're going to want to stand by your bill, you're going to want to defend it rigorously, and fundamentally I'm not going to criticise you for that because that is your job. However, it's pretty unusual in the legislation that this government has so far put forward, except we are still in early days, and that previous governments of all political persuasions have put forward, to have a body like this so comprehensively say the impact assessments are not fit for purpose. Do you accept any of their criticisms, and what are you and the department doing to answer those criticisms?
Well, thank you for the question. I think the first thing to say is it's not that unusual. In the last 3 years, there have been 10 red-rated bills, and obviously, as a Shadow Minister, you'll be aware that it was your government that was introducing those. I think there is a challenge here that all newly elected governments face, that obviously we have had a very clear manifesto commitment to deliver on our Make Work Pay agenda, also a very clear manifesto commitment to introduce legislation within 100 days of taking office, and that means that by definition there isn't the time and scope for the kind of normal dialogue you would get between the department and the RPC to actually have the informal conversations before the final impact assessment is published. So I think there's a fundamental challenge there. There's been a lot of work undergone in opposition, as you would expect, developing our policies, but of course because that's not part of the formal process, we're not able to take that into account. And I think that if the alternative was for us to be waiting 6 or 12 months before we got this impact assessment into a position where the RPC were happy with it, I don't think the public would really forgive us for having that kind of hiatus between taking office and actually legislating. I think that it's also worth saying that if you look at the individual impact assessments, actually 2/3 of them have been green-lighted. So they are actually getting approval from the RPC. We acknowledge that there is more work to do on some of them. We're going to continue to work with the RPC. I think I have a little sympathy with some of the difficulties the RPC had in terms of coming to their conclusions. I think a good example of that is the Minimum Services Act repeal, which it is noted was red-rated when it was introduced as an act and a bill anyway. And so the fact that that was poorly evidence-based in the first place and has never actually been used whilst it's been in force meant it was very difficult for the RPC to actually have any real evidence about what the impact of a repeal would be. Now, I think our critique would be that the reason for that is that it was unworkable anyway. So I think that But I understand in the circumstances why the RPC would have some difficulty making good judgment on that. I also think in terms of some of the other measures where they said there was no evidence base, for example, some of the equalities measures, I think we heard some pretty clear evidence, not just today, but also on Tuesday from the Fawcett Society and Pregnant and Screwed about some of the real impacts on individuals about the policies in the bill. I think, would say that I don't think there was any real evidence coming forward that there wasn't a need for this legislation. There wasn't a general thrust from most witnesses that this was something that was dealing with some of the challenges in the labour market, except not every witness said that, but that was generally the case. But of course, as we move forward, as we get more evidence, we will happily work with the RPC to try and improve those reds to greens.
Thank you for that answer. We'll explore that more in coming weeks. Can I ask, I accept the political narrative around doing something in 100 days. That's well established for governments around the world. Governments of my own party in the past may well have been guilty of it too. However, this is a big reforming piece of legislation. I might not agree with all of it, but I accept it is a big reforming piece of legislation, which we have heard a lot of evidence on, and it's obvious to anyone that reads the bill, does have an extraordinary requirement for secondary legislation down the line. Beyond the political optics, was there any reason to have to get it through in or published in 100 days, given that you have a mandate through to, what would it be, 5 years plus August 2029?
Well, look, I think it's important that we do stick to our promises, and this was something that was very popular with the public during the election. I think they wanted to see action quickly. We've had 14 years of atrophy and decline in the labour market. You're obviously not going to agree with that comment, but that would be our analysis. So the need to act quickly was there. A lot of this is not actually going to become law for a number of months, if not years, particularly unfair dismissal. We're saying it's going to be autumn 2026 at the earliest. So there is an awful lot more time to continue to engage and consult. We intend to do that. And of course, because of the nature of employment law, a lot of it, because it is very detailed, is developed in secondary regulation and also in codes of practice. And that's the completely normal practice, and that's why a lot of it is framed in this way.
Two more points from me, if I may, Sir Christopher. The first one is clearly some of the most striking evidence we heard that didn't agree with much of the bill was from Luke Johnson and Michael Lorimer earlier. Do you feel that the government has engaged those that run businesses, those that do employ people in the private sector, as opposed to representative bodies of businesses, enough in the drafting, the putting together, the research around this bill?
Yes, I do. I have to say that I didn't agree with much of their evidence. That's probably, I think it would be fair to say they're an outlier in terms of what we've heard whilst we've engaged with businesses. I think most businesses have understood the importance of actually engaging and enhancing workplace rights. They see the benefits of that. I can provide you with a list of all the organisations we've engaged with. It's certainly in terms of it's over 140 organisations. The majority of those are actually employers or employees' organisations. So I think we have been pretty comprehensive, and we're continuing that next week, and we will continue to do it for the rest of the passage of the legislation.
Okay, and my last point, which I hope might actually be more consensual as we move forward on this. One of the sides of this coin I was actually very sympathetic to before we started this bill committee anyway, and the other one, actually the evidence today has given me food for thought. The first part being the bereavement leave in the event of pregnancy loss, which is a position I have a lot of sympathy for, and the other being this differential we heard about from Dr. Stephenson earlier around the maternity pay versus maternity allowance and how that intersects with universal credit. I thought that was a very powerfully made point. Is the government willing to consider, well, I'm not expecting a cast iron answer now, but willing to consider changing this bill to incorporate those two asks? Well,
look, I have sympathy with what was said there. I think probably the first thing to say is that the actual sort of rates for maternity leave and allowance are set by the Department for Work and Pensions. So I probably can't say much more than that at this stage, although I have had some initial discussions with them about what we can do to actually reform this area, because we recognise it's quite an outdated system.
And on the bereavement leave?
Well, again, that's something I'm sympathetic to. I understand the Equalities Committee are actually undertaking an inquiry in respect of that at the moment, and we're going to look at see what they say in that regard as well.
Sarah Gibson.
Thank you. I have three quite short points to make. One of them is, I'm assuming you are quite concerned that we have had various sides talk about the fact that the bill will not encourage employers to take on new staff, which I think probably goes very strongly against what you're hoping to do in terms of getting Britain working again, and which is something to be applauded. And I'm particularly concerned about how small businesses will cope with the changes around probation periods, and I'm wondering whether you'll be prepared to sort of consider some changes to those probation periods. My first question.
Okay, so there were two questions there. I think in terms of the probationary period, there is going to be more work done on that. I think the evidence that I picked up was that most employers feel that 6 months is about the right period, and I think the reason why we've expressed a preference, which we're obviously engaging on anyway, for 9 months, is that we do recognise that there will be occasions when people might be almost on the cusp of being hired or fired at that point, and the employer just wants a little bit more time to work with them. We think that's a reasonable point, and we've responded to employers' concerns on that. But I think as we move forward with this legislation, we'll certainly be looking to ensure that all businesses, particularly small businesses, have readily available, easily understandable resources so that they know what they need to do. I think that we don't want to set a lot of laws that just allow employers to fall into traps. What we actually want them to do is comply with the best practices, which is what we're trying to set out in this bill.
I have to say, if the Minister considered that to be 2 questions, I therefore have 4. To make that point. That my second, your third question, is to do with the fact that we've had quite a lot of evidence concerning the issues around sick pay and the fact that it is so much lower than almost everything else. And as any employer will know, having employees limp in when they're sick is actually counterproductive to those who are not sick and to themselves in getting better and being on 100% form. So is looking at sick pay and the amounts of pay for people on sick leave something that you are interested in considering?
Well, look, I think we all recognise the point that was made by a number of witnesses. I think even Matt Hancock, when he was Self-Secretary at the pandemic, said that he didn't think that SSP was a rate anyone could live on. It should be pointed out, though, that this is actually within the remit of the Department for Work and Pensions. The Secretary of State has the ability to set the rate, so I can't really tread on their toes. And I think what we would say is that we recognise that at the moment there are several million people who don't qualify for statutory sick pay at all, and our focus on this bill is actually making sure that they qualify for that right.
Fair enough. And the last point I have is a point that was made earlier by one of our witnesses around, which possibly comes under the Department of Work and Pensions as well in that case, which is to do with losing your universal credit when you take on employment, and if that employment is flexible, because that's what you need in order to get yourself back into work in a gradual form, that because that flexible work can range, you can end up with, and I've had cases of this in my own constituency, of people trying to juggle the numbers between what they're entitled to in universal credit, what they think they're going to earn, then find that they didn't earn that much or they earned slightly more and being penalised. And I have to say, sitting down trying to do the maths with them, it was unbelievably complicated to work out whether they were in breach of their things or not. And I do feel that there's some kind of simple guidance. You know, you can imagine a website where you just put the numbers in and it tells you, so that people don't feel so scared about taking on part-time or flexible working while claiming universal credit.
I take the point. I don't want to deflect again, but again, it's really the Department for Work and Pensions. Yeah. But I think, look, what we're trying to do with this flexible working is make sure that as many people are able to work in circumstances that suit them. We think, you know, if we get this right, it's going to be transformative to lots of people who are locked out of the labour market at the moment, and that's what we're trying to achieve here.
Thank you.
Chris Murray.
Sorry, thank you, Chair. Could I ask about the evidence that we heard about industrial relations, both from representatives of business but also from the many trade unions that we heard? How do you see this bill affecting industrial relations in Britain, and what do you think will be the long-term impact of that on the economy?
Well, I think what we'd say is that over the last 14 years there's been a pretty hostile environment to trade unionists. I think that's ramped up in recent years, which is why we have seen in the last couple of years the highest numbers of industrial relations disputes for about 40 years. The solution to that is not to continue to legislate to make it harder for people to strike, it's actually to change the culture and attitude towards industrial relations. So what we're trying to do is make sure that trade unions have the opportunity to operate on a level playing field, and we have heard, I think, plenty of evidence from both employees and from trade unions that when there is a constructive relationship, actually businesses benefit, individual workers benefit. There's plenty of evidence that actually trade union members usually have better pay in terms and conditions. That's recognised throughout the world, and that is something that we want to help facilitate under this legislation.
Thank you.
Nick Timothy.
Thank you, Sir Christopher. Do you personally want to see increased unionisation in Britain, and do you hope and or expect that the bill will deliver it?
Well, I think that's actually a challenge for the trade union movement. I think that they would accept that this is really up to them. Personally, as a trade union member, as someone who's been actively involved in the trade union movement for many years, I see the absolute advantages and benefits of being a trade union member. But it's really up to them to be able to get into the workplaces, explain their advantages to the workforce, and then engage on a tripartite basis with government, with business and with the workers to actually improve the working lives of everyone.
Thank you. And can I ask one more? Thank you. Can you name a CEO of a real business, not a representative body, employing more than, say, 100 people, who would say that this bill is unambiguously good for the economy? And how many of them do you think there are?
I would imagine that there are quite a few. Certainly when the bit, well, I can't name individual CEOs. I would say Octopus have been very positive. Sainsbury's have been very positive. The Co-op, I think, as we heard today, have been very positive. I think the CBI welcomed the bill. They welcomed the engagement as well. Make UK as well. There were quite a lot of organisations on the employee side, and I think that's been reflected in the evidence. Are generally welcoming of the intentions of this bill.
But the only real business people who have been here have been unambiguously against it.
Well, I think you'll find the Co-op is a real business and employs an awful lot of people.
That is true. That is a correction.
Alison Hume.
Thank you, Sir Christopher. Minister, we've touched on adult social care today. There are 1.6 million workers in the sector. I know that the news of the adult social care negotiating body has been warmly welcomed, but can you expand on why a fair pay agreement is so important for the adult social care sector?
That's a really good question. I think first of all, one of the reasons why it's important was in the question, which is there's 1.6 million people employed. That's a huge part of the economy, which at the moment, unfortunately, as we've heard in the evidence, is characterised by poor terms and conditions, high numbers of 0 hours contracts. Quite often minimum wage is not enforced properly, and these are people doing really, really important jobs in our society. They deserve a voice, they deserve a collective opportunity to raise terms and conditions and also work with employers to develop that career path. So I think this is a really, really transformative structure that hopefully will change the lives of many working people and, of course, the people they care for.
Uma Kumaran.
Thank you, Chair. Thank you, Minister. We heard from two business voices today, which are not entirely reflective, perhaps, of some of the rest of our views. I've got over 12,500 businesses in my constituency in Stratford and Bow, over which 5,500 are small and medium-sized businesses. I've met lots of them over the course of the last year. I certainly haven't heard similar views. We heard from legal experts as well, saying that the bill brings us closer to OECD norms than perhaps what was said. Can you tell us how this bill will benefit businesses and how businesses will benefit from this bill?
Well, I think there's generally an acceptance, both in terms of the economic analysis that we've heard from some of the witnesses today, but also from the businesses themselves, that getting a motivated, engaged, retained workforce is good for productivity, it's good for the business overall. Having a more engaged and well-remunerated workforce has been shown to actually boost profits. I think the fact that the OECD were referred to by the Resolution Foundation as a body that believes that greater workers' rights do actually improve the economic outcome of the country is a really important factor that we need to emphasise today.
Michael Wheeler.
So picking up from that last question, thank you, Chair. So we've heard how this bill will benefit employers. What other groups of people in the country do you think this bill will benefit?
Well, there's an awful lot of people who are going to benefit if we get this right. I think that talking about people who don't know from one week to the next how many hours they're going to have, whether they're going to be paid enough to put food on the table, our reforms on 0 hours are going to really help with that. People who can be arbitrarily sacked for no reason,
for the first 2 years of their employment. That's about 9 million people. They're going to benefit from that. The 1.6 million people in the social care sector, they'll benefit. 900,000 people a year will benefit from bereavement leave entitlements. And overall, as ACAS have suggested, the cost of disputes to the economy can be up to £30 billion a year. Just imagine if we could shave a fraction off that, what a difference that would make. And I think that this bill is really setting a new culture in our country about how we do workplace relations. It's actually putting the value of the worker-employee relationship with businesses at the heart of everything that we do.
Marie Tipple.
Thank you, Sir Christopher. 7 children in every classroom of 30 in my constituency of Penistone and Stocksbridge are in poverty. Can you set out more broadly the economic benefits of the bill, many of which were set out in the TUC's report this week? And in particular, whilst you've mentioned some just now, focus on the economic benefits for working people and working families.
Well, obviously the TUC report is something that isn't an official government document, but it's got some very interesting figures. They reckon that up to £974 million could be gained from reducing the number of days people take off due to stress and anxiety because of poor working conditions. Another £930 million a year from improved staff well-being. £168 million a year from improved minimum wage compliance. £510 million a year from reduced industrial action, £8 billion a year potentially from improved industrial relations, increased labour market participation, and there's a number of reasons why that might be the case, could be up to £2.6 billion a year. We obviously don't know how much of these figures are to be delivered on because there are an awful lot of variables in that, but it's a very impressive attempt, I think, to try and quantify in a way that I think because of the rules of government we can't really, but it's a really impressive way of quantifying what the positive impacts on this bill will have on the wider economy.
Elizabeth.
Thank you, Chair. Thank you, Minister. You spoke about earlier some of the engagement that you've had in the past on this bill, and some of the witnesses earlier today spoke about tripartite meetings that they'd had with government, union and businesses, but I was wondering if you could set out some of the planned future engagement that you've got around this bill.
Well, engagement continues. There'll be more engagement next week. We're meeting a group of small and medium-sized businesses, but to date there have been 140 different stakeholders attend official or ministerial meetings, and you will have heard from many of the witnesses that they have actually been quite impressed, I think, with the level of engagement and how we've listened to concerns expressed over the legislation. And of course we undertook extensive engagement in opposition. We will continue to do that, and we're moving through some live consultations at the moment, but as we develop our bill and as we develop some of the regulations that will follow it and the codes of practice, there will continue to be engagement throughout this. I think we are very clear that this is the best way to deliver excellent legislation, and we continue to do so.
Lawrence Turner.
Thank you very much, Chair. And Minister, over the last 2 years we've seen some of the highest levels of industrial action since the 1980s. Could you tell us a bit about what effect you think this bill will have on the conduct of industrial relations?
Well, I hope it will have a positive impact on industrial relations. I think that the way we saw strike action spiral in recent years was probably as a result of a frustration with a government that wasn't listening to the voice of workers, that wasn't prepared to address their concerns, and actually was actively moving to try and frustrate the legitimate acts of trade unions to take industrial action. So it's about the culture, and it's about the level of engagement as much as it is about the legislation. But I think that there is no suggestion, as far as I can see, that this is going to massively increase strike action, as some people might have suggested.
If there are no further questions, then can I thank the Minister on your behalf for his evidence. Thank you very much. And I think the Government Whip has something to say.
I
I beg to move that we be now adjourned.
The question is that the committee does now adjourn. If any of you say aye? Aye. Contra no, I think the ayes have it, the ayes have it. So further consideration is now going to be on the 3rd of December at 9:30. Thank you very much for your attendance. Order.
The Boothroyd Room. Portcullis House, 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 the Boothroyd Room.